Hear ye, Court of Appeals for the State of Michigan is now in session. The Honorable Colleen A. O'Brien, the Honorable Randy J. Wallace, and presiding the Honorable President P. Mariani. All persons having business herein, draw near, give attention, they shall be heard. God save the United States, State of Michigan, and this honorable.
Okay, good morning. All right, on behalf of myself, Judge O'Brien and Judge Wallace, welcome to the Michigan Court of Appeals. This is panel 4 of the court's July 2026 case call session, and we are ready to begin our 10 a.m. session for the day. Thank you for being with us here today. A few just quick opening remarks. Counsel, please remember to put your appearance on the record before you begin arguing. If your clients happen to be here, please just let us know that as well so we may welcome them. Counsel, I'll also ask that you please keep track of your own time. I'll do my best to help you, but I'll ask that you take responsibility for that. And if you have another endorsed attorney that you're sharing time with, please let me know of that at the outset as well. A reminder that in cases where both sides are endorsed for oral argument, it's a maximum of 30 minutes per side, and where only one side is endorsed, it's a maximum of 15, and that's subject to any orders of the court that may have provided otherwise. Please rest assured that we are very familiar with the relevant facts and case law for each case. So please focus your time today on your most salient points, or the points that were perhaps not as clear in your briefing as you would have liked. And of course, any questions that we may have for you. Lastly, and importantly, because these proceedings are being recorded and will be posted publicly online, in cases that involve children or other vulnerable or protected individuals, we ask that you please don't use those individuals' names on the record, but instead refer to them in here today by their initials or another non-personally identifying way. And lastly, counsel, I apologize in advance if I mispronounce your client's names. Please correct me if I do so. So that is it for me. I think with that, we're ready to get started. So we'll call the first item of the day. That's item 14. Case number 367-915, People v. Perry.
Good morning, Your Honors. Jessica Zimbelman from the State Appellate Defender Office on behalf of Charles Perry. I'm going to focus on the first 2 issues in the brief. Of course, I can answer any questions that the court has about the other 2 issues. But I want to talk this morning about the stop, and I want to talk about the search. First, this court, we filed a motion for new trial asking, in the alternative, an evidentiary hearing, which the trial court denied. This court should give no deference to that opinion of the trial court. The trial court, in issuing their ruling and denying the motion or the Ginther hearing, cited the great weight standard from Lemon and the 6,500 rules in making their decision. Those are not applicable to the issues we raised. And this court should remand for an evidentiary hearing about why trial counsel made the decisions he made in challenging only the stop. If Your Honors will recall from the record, trial counsel thought he filed a motion to suppress to challenge the search, but he didn't. So the only thing that was addressed in the trial before trial was a motion to suppress that trial counsel filed based on the fact that the videos of from the officer's body cam didn't support that a wide right turn actually happened. And even if it did, there's nothing in Michigan law that prohibits a wide right turn. Trial counsel missed a whole lot of arguments that he could have made to challenge the stop, let alone the search. And I want to talk about the stop first. The prosecutor in their brief to this court on page 3 says the people readily concede that the officers expected to find drugs in the stopped vehicle. This expectation, however, was legally irrelevant to the validity of the stop. And while we know, in our opinion, as the brief lays out, that Wren was wrongly decided, we do know that an officer's subjective intent can't be taken into account when determining the constitutionality of a stop. But there still needs to be probable cause. There wasn't probable cause here. We know from Hughes that probable cause means that there's evidence related to a specific criminal activity discovered in a particular place. All the information here came from the informant, Frank Clay, was about my client, Charles Perry. not the car. And you can see that as well in the prosecutor's brief to this court on pages 8 through 11, what they cite as the basis for the probable cause to stop the car for possible drugs is that Clay was a participant in the crime. Clay's the informant. They were based on his personal observations. He was speaking directly to the police versus over the phone, and his statements were against penal interest. But again, his statements were about Charles Perry bringing drugs from the east side of the state to Benton Harbor. That's the information he gave the police. That is not sufficient evidence of probable cause, certainly, to pull over this particular car, especially when the officers are saying that they pulled it over because of a wide right turn. So trial counsel should have made those arguments to challenge the search of the car, or the stop of the car.
So you're
And-
saying that the traffic violation wasn't sufficient to stop the car?
Correct, to search for drugs. Because essentially what they're saying,
Well, I guess just help me break it down into
Sure.
steps. So, I mean, you're stopping the car first.
yes,
You have the traffic violation.
you can
that-
stop the car for traffic violation, absolutely. But how I read the prosecutor's brief to this court is it wasn't actually the wide right turn. We were stopping it to search for drugs, and that's fine because we had probable cause to search the car for drugs. I'm saying there was not probable cause to search this car for drugs. To stop the car to search for drugs, which I think
But does it need to be if we think the traffic violation was enough? I understand you dispute that, but
that's a tougher argument for me, Your Honor, because of the way the law is now.
right.
Do I think it should be okay for a police officer to stop anybody for any civil infraction and that's constitutional? No, I don't think that.
But we're living under Wren, and
Correct.
that's where we
Living under Wren, it's tougher. Absolutely. That's why I want to talk about the search, because again, trial counsel did not challenge the search of the car. The prosecutor in this court has now given a fifth reason for the searching of the car. And I think that's because the prosecutor knows on appeal that the other four reasons are shaky. So in the police reports, again, these were submitted as an offer of proof in support of a motion to remand, where some of this should be argued and established in the trial court. The police reports say they stopped him for a wide right turn. Well, under Rodriguez, we know the search wasn't okay because of the stop for the traffic violation. So that's reason number one that the police or prosecutor gave to search the car, including under the hood. Rodriguez, you can't extend a traffic stop beyond investigating the traffic stop. So we know that's not a valid basis to search the entire car. The second reason the police gave was the allegedly open bottle of tequila. And as you can see from the body cam footage and in the brief we submitted, that should have been open and in plain view. The officers didn't know if that bottle of tequila was open until they pulled it out of the car. That's not a valid basis to search the entire car. Third was this alleged smell of marijuana coming from the car. We know under Armstrong, that's insufficient to search the entire car. So, and then we also know that the officers, once they stopped the car, pulled everybody out, got their IDs, which is problematic right there. Because again, you're prolonging the investigative stop of the wide right turn and taking everybody out of the car and getting their IDs. Once they get their IDs, all three of them are on parole. So now they're invoking the parole search exception. That shouldn't be a reason either under Rodriguez. So now we are left.
Why is that not a reason? Is it just because you're saying it took too long? Like it went outside the scope of what was strictly necessary for the traffic
Yes,
violation?
absolutely. You have a driver who's allegedly making a wide right turn. To investigate that, issue a citation, you're going to get the driver's license. And then, but
The driver was on parole, right?
The driver was on parole.
Right.
And there is, I do make an alternative argument in my brief, based on Michigan's Constitution, a concurrence by Justice Welch in the Montgomery opinion, that we do have broader protections for people on probation and parole than the federal Constitution. But those, the parole search and Rodriguez are tied together. So now on appeal, we have the prosecutor saying None of that matters. And this is on page 13 of the prosecutor's brief. The stop was only ostensibly based on several traffic violations. And in reality, the search was grounded on probable cause that drugs were being transported in the vehicle. Again, this is the exact Monday morning quarterbacking that this court doesn't enjoy, should I say that, in claims of ineffective assistance of counsel, where you might have an appellate attorney come in here and say, well, trial counsel should have done this, but this court recognizes that trial counsel had their own reasons. The appellate prosecutor here is doing the same thing. There were 4 reasons given for this search, and if I had to guess, the prosecutor thought those probably aren't going to hold up very well for all the reasons I've already discussed. We're going to say this was a search based on probable cause. And again, this court could remand for a Ginther hearing or an evidentiary hearing so we could flesh some of this out about what really happened, and what the police knew, why they searched, whether there was in fact probable cause. I also want to briefly, before I close, address standing. This is another thing that trial counsel should have done, because the trial court, while this court should not give any deference to their opinion on the motion for new trial, did mention that Mr. Perry did not have standing to search or to challenge the search of the car as a passenger. I believe that trial counsel should have established this. I mean, he should have challenged the search, but also could have established standing. In the offer of proof I submitted to this court in support of the motion to remand, I attached police reports. Rodriguez Russell said the car was his wife's and Charles Perry had been driving it up until that day, moving things for a cousin. Robert Russell told the police that when they left Flint, Charles Perry was actually driving the car, and Mr. Perry had been driving it in the days leading up to this. So under Meade, this court needs to address whether society is prepared to recognize this expectation of privacy as reasonable. I think in today's society, people do expect that if they're in the passenger of a car, that they're going to have some expectation of privacy. We know that not everybody can afford vehicles and often rely on friends, family, rental cars. There's all sorts of reasons that you might have possessory interest in a car that you do not own. And but for a twist of fate, Charles Perry could have been driving this car when he was pulled over, and then we wouldn't be discussing standing.
Well, that might make sense for the passenger compartment or the glove box, which is in the passenger compartment. But I mean, you really think an average reasonable person has an expectation of privacy when they're in a passenger of the car as it pertains to the engine compartment?
Well, that's an interesting question, Your Honor, because Meade, of course, dealt with the passenger's own backpack, right? His personal possessions in the car. And the question is whether society is prepared to recognize as reasonable a privacy interest in every inch of the car, because of course these drugs were under the hood near the engine. And I say yes, because people need to be able to enter a car and feel secure from arbitrary police action. And the court in Meade said a person can get in a car without leaving his Fourth Amendment rights at the curb. And I think if we get too much into, well, this particular space of a car has privacy interest, but this particular place doesn't, it cuts holes in the Fourth Amendment and Michigan's Constitution that aren't there.
So let's back up for a minute, and I want you to explain to me what you'd like to happen with regard to Wren, because what I think you were arguing was that the Michigan Constitution should provide more protection than the Fourth Amendment. And so I guess this state shouldn't follow Wren, but of course we know that there's been multiple published decisions by this court and the Michigan Supreme Court that have followed Wren. So I suppose what you're arguing here is like a change in the law, right?
It is a change in the law, but I would say that there is, because Michigan's Constitution has broader privacy protections, our corresponding amendment is different in quite a substantial scope from the Fourth Amendment. There is a compelling reason for Michigan to depart, if you want to say depart, to not follow Wren. And what this court could do, there's a case pending in the Michigan Supreme Court right now called Jennings that is in part, it's a double jeopardy case, but it's in part addressing this idea of when there's a compelling reason for Michigan to read their constitution differently than the federal constitution. That opinion should be out in a couple of weeks. This court could hold this case in abeyance until Jennings is decided to see what the Michigan Supreme Court has to say about when there are compelling reasons to look at our constitution differently than the federal constitution. Wren is a perfect example. And in the brief, of course, we cite objective studies that have been done in Michigan that do show the racial disproportionality of stops and arrests on the roads for people of color.
You'd agree, though, that as it stands today, because there have been Michigan Supreme Court cases that have adopted Wren, this court wouldn't be able to do anything about that today, other than hold it in abeyance, as you suggested.
Yes, Your Honor, I do.
Okay.
But even with Wren, I think this court should remand for an evidentiary hearing to sort through the facts, the reasons trial counsel did and frankly didn't do everything he should have to try to suppress this evidence from a bad stop and a bad search. Thank you.
Thank you.
Thank you.
Okay, that case will be submitted. Moving on to item number 15, case number 372257, People v. Smith.
Good morning, Your Honors. May
Morning,
it please the court, Maya Menlo of the State Appellate Defender Office appearing on behalf of Mr. Smith. I've raised 4 issues on appeal. I'd like to touch on each issue briefly and prioritize, of course, answering this court's questions. In the first issue, we have raised the fact that there is a missing record here, and that is the answer to the question that the jury posed during their deliberations. This creates several constitutional issues, and I will start with the right to appeal. The prosecutor says in their brief that because I'm standing here because Mr. Smith has an appeal pending before this court, his appellate rights couldn't possibly have been infringed. But that's a misreading of Craig, which is the chief case that I relied on in my brief. That itself was a direct appeal where appellate counsel filed a brief in this court, and this court granted relief on direct appeal. And so the fact of having a direct appeal doesn't negate the violation of the right to appeal that occurred here. The missing record here goes to the very core of Mr. Smith's conviction. And as we stand here, we simply do not know what actus reus he is convicted of, which again, it raises multiple.
I'm sorry.
I'm sorry. No.
I mean, that does happen sometimes. It may be under like slightly different circumstances, but we have case law where you don't necessarily know what the theory of liability was, right? And we have cases that then say, okay, well, we look at the 2 alternatives, and if there's relief for either, you get it. So it seems like we're kind of in that circumstance here. We have a conviction and acquittal. We don't have the specific answer telling us which is which. Mm-hmm. So why is it not, I guess, adequate to proceed with the appeal saying, okay, well, we'll analyze the issues under both. We'll analyze the sufficiency under both, and then say, hey, if you get relief under either, we've got to give it to you because we can't say for sure. But why is that not adequate? Such that there aren't constitutional rights implicated by that solution?
Well, Your Honor, I agree with you that if on other issues in this case, you find that relief is warranted, you can grant it based on the fact that you don't know what Mr. Smith is convicted of. But that in itself, the fact that we do not know is itself a unique harm. And here we have a unique situation where it was not a Cook's type of scenario where you had many instances of the exact same conduct alleged. We had different types of conduct alleged, and one of those was something the jury flat out rejected. And here too, there's a missing record. And in instances like Cook's, where the issue is a pure lack of a unanimity instruction, for example, there's not a missing record, and that implicates different rights than in the unanimity context. And frankly, depending on the answer the trial court gave to the question, I would have raised a unanimity argument, but I can't because I don't know what it was that the trial court told the jury when they asked that unanimity coded question. And I would like to actually press on that a little bit because the prosecutor says that this question could have been answered in only one of two ways. Count one goes with allegation A, count two goes with allegation B, or vice versa, right? That's what the prosecutor thinks. But that's not quite true. The trial court could have said any number of things, and I have some examples that I'd like to offer the court. First of all, the court could have said what we hear very often, which is use your collective memory of the evidence in the instructions, right? That could have been said. The court could have said either incident can form the basis for each count since the counts are identical. I could see that. The court could have said that's up to you as the fact finder to decide. The court could have said, I cannot provide additional instruction on that, so please refer to your instruction packet, and so on and so forth. So there's a wide variety of things that the court could have said. Some of them may be more proper than others, but because we don't know here, the relief under Craig is to vacate the conviction.
But we also, I think something we do know from the record is that the answer that was given was agreed upon.
That may be true. And so, well, it is true, but there may have been an opportunity for me to raise an ineffective assistance of counsel claim if, for example, one of these sort of poor instructions that I just offered had been given. I would have said that trial counsel should have objected. And given that there was an acquittal and conviction on a lesser, I think there's great argument for prejudice here. It's a credibility contest, and we may get into that more later. So also embedded within my first issue, we have this double jeopardy claim, and I realize that that is a little bit unique. And I've cited some United States Supreme Court case law, some Sixth Circuit case law, which of course is only persuasive for this court. But I do want to just put a finer point on something, which is that I cited Russell in my brief, which is the United States Supreme Court case, to make clear that double jeopardy violations requiring relief can occur as early as the indictment stage. So we need not wait until some future successive prosecution. And that's directly in response to the prosecutor's argument. They say that, well, because there's been no effort to successively prosecute Mr. Smith, then we can't address this issue. It's not ripe, is their argument. But in Russell, in Valentine, these are cases where an individual was convicted, sought relief on appeal from that conviction, and was granted relief. There was no need to wait until some later time. And the reason is because if there are infirmities in the verdict, there are infirmities in the conviction, those need to be addressed now. That's the line of cases that I've cited.
But
I'm sorry.
here's here's my question about that. As soon as this jury panel, was seated,
Mhm.
as soon as they were sworn in, assuming there was not a mistrial, and there was no mistrial here, and your client was entitled to res judicata on all the charges the second they got sworn in. So how can there be a double jeopardy issue here?
Well, Your Honor, suppose this court vacates the conviction, which I maintain that it should. The remedy should be a dismissal of the charge, the remaining charge of which he was not acquitted, whatever that is, right? Because we don't know what the facts are underlying that. But the remedy that this court should order pursuant to Russell and Valentine is that we don't actually proceed to that new trial. Because we don't know what he was convicted of in the first place, the remedy is dismissal.
Well, does
Okay.
that answer the constitutional question then? It just shapes the remedy if he's entitled to relief on appeal?
Well, yes and no. So if the court disagrees with me on issue one, except insofar as Judge Wallace and I were discussing, then this court should order a new trial on one of my other issues and then vacate the conviction and charge due to the error of Valentine, Russell, et cetera. But I maintain that issue one entitles me to vacation of the conviction and dismissal of the charge because of the unique issues raised. And that's precisely what happened in the Russell and the Valentine cases.
Thank you.
Certainly. If there are no further questions, I'll move on to issue two. And in fact, I'm not going to dig deep into the sufficiency argument. I think it's been well briefed. I would just mention that if you agree with or follow the prosecutor's suggestion that the Super Bowl incident is what formed the basis for conviction, she's basing that on some of the arguments that were made to the jury. The CSC2 statute does not criminalize touching someone's waist. And so inferences can really only get us so far.
But why is the fact that it's an attempt not relevant there? I mean, it seems like what I would understand the theory of the prosecution to be is that, well, yeah, maybe that contact with the, statutorily specified area did not occur, but he was trying to, and she didn't want it to, so she resisted. So why do we need that contact to be accomplished for the evidence to be sufficient to sustain an attempted CSC2?
There are two reasons. One goes to the question Your Honor's asking, and the other goes to the intent element, which is, of course, something the prosecutor has to prove in order to sustain a conviction for attempt. So first, frankly, it's just a bridge too far for me, Your Honor. I think touching of a body part, any body part.
Well, the evidence was thumb in the waistband of her underwear by her navel. So I don't know if it's not touching her on her shoulder.
That's true, Your Honor. And I think ultimately we may disagree, but to me, the waist being specifically not in the CSC2 statute, and the testimony not supporting that his hand was moving in any way toward one of the specified areas screams sufficiency of the evidence to me. Now, moving on to the intent piece, this was something that allegedly occurred in a family event in the middle of a space where there were multiple people present, adults, children, and that to me belies any proof of sexual purpose, which is, again, something that the prosecutor must.
Well, it's reasonably construed. It's actually not specific intent, right? For purposes of CSC2, it just has to be conduct that could be reasonably construed as for that purpose.
And again, I think the public nature of the act goes to sufficiency on that element. In issue 3, we've addressed the excited utterance objection, or rather the evidence that was admitted as excited utterance and was objected to at the time of trial. This has been briefed and argued multiple times now, so I will just mention that excited utterance is very specific to a circumstance where someone is startled. And here there's no evidence that this complaining witness was startled at the time she made this statement. Of course, time is one factor. It's not the only factor. And 10 hours in the Smith case was nearing the outer limit. Here, this is months that have gone by. The unpublished case the prosecutor cited in their brief also involved a matter of hours. My read of that case is that it was even fewer hours than in the Smith case. And here we have a much longer period of time.
So the fact that she's still upset about it is not enough.
Correct. Yes. And there's case law that very clearly says that. There's Straight, there's Smith, there's other cases that have been cited so far. And again, I don't think the unpublished case that was cited goes to that at all. And in any event, this was just something that occurred way too long after, and the evidentiary proof wasn't there that it was the incident that elicited whatever startled reaction. And in fact, as I said, there wasn't necessarily proof of any startled reaction.
Isn't that maybe harmless error though? Because this was just a very small part of the prosecutor's case.
Well, Your Honor, in a different case with, for example, DNA, I might agree with you. But here we have a credibility contest and we have evidence that was inadmissible because there was too much time to fit the excited utterance exception. So that's all about lack of time to fabricate. So here we have evidence that should not have been admitted because there was too much time to fabricate, and it's being introduced to counter a theory of fabrication. So I'll put it a different way. The excited utterance exception applies only when there's not enough time to fabricate, and that's why we think that evidence should come in. It shouldn't have come in here, and I think that's what Your Honor's getting at, is that maybe that was an error. The purpose of it coming in was to demonstrate that the complaining witness did not fabricate this allegation. And so there is a irony there that I think inures to my benefit, which is that lack of fabrication is this big theme for the prosecutor. And when you're introducing admissible evidence to prove your lack of fabrication theory, it really does harm the defense. And again, this is a preserved error that was objected to at the time. I'll move on to my fourth and final issue if there are no further questions on the evidentiary piece. This is the Sex Offender Registration Act issue, and the prosecutor filed the supplemental authority, People versus Cardaz, from the Michigan Supreme Court. So I'd like to talk about that for a moment.
And let me ask, I mean, we have Cardaz, now we also have Shannon.
Yes, and
From
I'd
this
like to
court,
address Shannon as well.
Yeah.
Yes. So briefly, Cardaz. first, of course, decided that 2021 SORA is punishment and then dealt with a cruel or unusual punishment claim that came in a couple of different flavors, right? We have the as applied challenge, we have the facial challenge.
Here we're just as applied. Is that right?
Correct. So here we have an as applied challenge. Yes. And I would agree with counsel for the people that there's no facial challenge available as a broad SORA is unconstitutional for everyone type of argument. I think there's a categorical challenge available that I'll get to in a moment here. And actually, let me address that now before I address Shannon. So a categorical challenge would be something like people convicted of attempted CSE2 cannot be required to register because it's cruel or unusual, right? So that would be a rule that this court could make that would apply to a group of people. And so in that way, it sort of looks facial, but it's not quite, because it doesn't go so far as to say SORA is unconstitutional for every person, full stop. Okay, so I would encourage the court to reach that type of categorical ruling. And if not,
For attempts, don't.
I think
Hey,
that's one. Yes, sorry.
Why,
Your Honor.
what's the legal basis for that distinction?
Well,
Because it didn't, I mean, attempt, obviously, in this case, you can argue if she hadn't resisted as effectively, then it would have been consummated. So why does that affect whether he needs to register?
Well, I think it goes to prong one, which is the severity of the offense compared to the severity of the punishment. And of course, attempt is, by all accounts, the punishment that's available, the crime class, so on and so forth. It's a lesser offense than the complete crime. And so the court could look at that as to prong one. We already know from Cardas that the fourth prong, rehabilitation, is frustrated, in fact, by SORA. So I think the balance comes out differently when it comes to attempts. But here, too, we have lots more to support our argument. And this is where I will talk about Shannon. So in Shannon, we have a case involving somebody who was convicted of multiple counts of CSE4 against several victims, and who had, and I'm quoting from the opinion here, had not lived on the registry without reoffending for a significant length of time, nor has he provided evidence that he has a particularly low risk of reoffending. And so first, I will say that I think that's a little bit of a backwards inquiry. I think that in order to subject someone to the loss of liberty, the public shaming, the stigmatization of SORA, the state should have to prove that they will or are likely to reoffend. But the language of Shannon is that
It is
Mr.
what it is.
Shannon, I'm sorry.
Yeah, it is. I mean, it is what it is. Right.
Yeah, the language of Shannon is what it is. I don't think this is a holding necessarily. So I will just put out there that I don't know that this court can say that somebody must register on SORA unless they have disproven their likelihood of reoffending. I don't know that the court is bound to that. However, Mr. Smith does have something that Mr. Shannon did not have, which is a length of time on both bond and probation without issue. Okay, without any additional CSEs.
So our lower court file contains transcripts about a probation violation that occurred not long after
Mhm.
that. I understand, as technical versus non-technical nature was disputed on appeal, but the underlying factual basis for it does not appear to have been disrupted, and that indicated predatory conduct towards minors. So that seems like that's what the court found.
The court found, and if
The trial
I'm
court
mistaken,
found.
I apologize, but I believe what the court found was contact, mere contact with minor children, which was later determined after Mr. Smith had been in prison for, I think, almost 2 years or something like a year and
It
a
was
half.
15 months.
Thank you very much, Your Honor. 15 months that he should not have, in fact, been in prison for that technical violation. And so I would be corrected and stand corrected if the transcript suggests otherwise, but I believe it was the mere contact that formed the basis for the violation. Nothing like in Shannon, which was additional criminal conduct against minor victims.
I
And
will
so we
say-
have, I'm sorry.
I'm sorry, counsel. I know you have 15 minutes.
Yes, and I have not been keeping track of my own time.
And so you're at that. So I guess
Okay.
let me just ask quickly, does anybody else have further questions in
No.
particular? I guess you have a concluding remark that you'd like to offer?
Just as to the SORA piece, I would say that what we have here is mandatory lifetime public sex offender registration with all the attendant reporting obligations, privacy intrusions, et cetera, for someone who was convicted of what I'm not exactly sure, but at worst attempting to touch a child's leg. And I would leave the court with that.
Okay.
Thank you.
Thank you, Counsel.
Thank you.
Good morning, Your Honors. Ashley Prue on behalf of the people, and I will disclose that we do have a family member of the victim in the courtroom today. I know sometimes judges like to know that. So I will address each of the issues since opposing counsel went through each of them. As to the missing record, I want to distinguish between the case law. It sounds like Your Honors have read it, but of course you have. But People v. Craig specifically says that a criminal defendant is only entitled to relief when he has been prejudiced because the existing and supplemental record is insufficient to review the defendant's, quote, specific allegations of error. This isn't a unique double jeopardy case. It's a double jeopardy case that is not ripe, because unless this court finds that one of the other issues has merit, there is going to be no retrial on these specific charges. It's not a question of what the defendant was convicted of. It's a question of what he was tried of and if he knows that. In Valentine even said that the error in the indictment could have been cured if the prosecutor had indicated which of the 20 of each type of offense had specific facts. That's exactly what happened here over and over on the record. Defense counsel even referenced a preliminary examination transcript that said count one, or I didn't say count one, but it said count for touching of the thigh in the drive-through and count for waistband at the Super Bowl. Defense counsel and defendant knows what he has been tried for, and he cannot be tried again on either count for double jeopardy. Valentine and the other cases cited were more so that they were tried for identical counts, and some of those counts didn't even have that many instances in the record. In fact, Valentine did not vacate the first count. It upheld the count that was proved on the record. So unless there are any questions about the double jeopardy issue from this court, I will move on to issue 2.
You did qualify that, though, in that you said if we don't award relief on any of the issues, then there's no problem.
Correct.
What if we do?
I would say, and I know that this has been discussed in the trial court, but if you do order relief that vacates the sentence, I would ask that you first require the evidentiary hearing. We had back and forth and off the record conversations about trial counsel may or may not remember.
Wasn't there efforts to settle the record below?
What?
Weren't there efforts? I mean, haven't we been down this? Haven't we tried to figure this out already? Or what hasn't been explored at this point?
So asking the trial counsel, what happened in the trial court was trial counsel just happened to be in the room at the hearing. There was no calling of witnesses asking, do you remember this? No refreshing of recollection with transcripts, the parts that I referenced. It was an off the cuff. Are you familiar with this case that happened several years ago? Both of those attorneys just kind of shook their heads, didn't even speak on the record. There was no evidentiary hearing. I don't think we need an evidentiary hearing, Your Honors, because I'm confident that this court will find that if there was a hearsay issue, it was harmless error, and that there was sufficient evidence for both of the charges. And it's up to the discretion of the jury to determine which testimony led to conviction. So I will move on, though, to that hearsay argument. The prosecutor, in addition to saying it was an excited utterance, in his closing specifically, one of the very last things the jury heard, other than the instructions, was, in order to convict, you have to believe the victim. You have to believe EH. He even said, well, I know it's not a jury instruction, but he said in closing, I can't put her brothers and sisters up here to tell you what they said. You have to hear that from the victim because it's hearsay. And he ultimately said what it comes down to is if you believe her testimony, her being EH, the victim, then there's guilty. If you do not believe her, not guilty. So this idea that this was some big pivotal theory of this case, that her sister's statement led to conviction, just isn't accurate from a reading of the whole record. And the substantiation of that theory wasn't to disprove a theory that victim was concocting the story. It was the consistent defendant's theory throughout the case that the sister that the statement was said to was concocting the story because there was evidence that she and defendant did not like each other. So it was not necessarily for the truth of the matter asserted. And the jury was told by the prosecutor, you have to believe the victim to convict.
All right. But I mean, as we know, arguments aren't evidence, arguments aren't evidence, arguments aren't instruction. So I understand your point about how it maybe, how the prosecutor was thinking about it, but I'm not sure how much work that argument does in terms of finding whether there is an error here, because obviously there's reasons why you can't put the evidence in, right, in the first place, because you hear it.
Well,
and it's not enough to just say, like, oh, okay, well, you can't actually think about that because it's already there, right?
I would argue that it could have been admitted for that purpose. Obviously, it wasn't. But even so, as Judge O'Brien indicated or asked about, I believe it's harmless error. It was merely cumulative. The victim had already testified. It was only a small portion of the sister's testimony. And again, it was in relation to, did you make the story up? Did you make the statement, the fact that she said something to you up? So I would argue that it's still a harmless error, even if this court finds error there. For the third issue, well, actually, I guess that was the third issue. I kind of went out of order. The sufficiency of the evidence. Again, it is for the jury to convict defendant of attempted. So, Your Honor, Mariani, you hit the nail on the head where the touching doesn't have to actually occur. And the testimony regarding both counts indicate that a jury could have convicted on either count. The fact that for the waistband count, the touching may not have actually occurred in one of the prohibited areas. It was under the waistband. It was near that area. And the testimony regarding that count specifically was that she was trying to get away from him as fast as possible and moved away. This public versus non-public, this was a house where he lived in. He was familiar with all these people. He was familiar with her. And I think we well briefed the other evidence of intent with the incidences of her being in the shower and him walking in, not respecting door knocking, other comments, having her sit on his lap, calling her baby girl, which is the same thing he called her mother who he was dating. Those are very sufficient evidence of intent. Regarding SORA, I will rely particularly or specifically on our brief and our supplemental authority. I did want to clarify that case law does say that the burden is on defendant to provide individualized assessment of whether or not he or she will reoffend. That is in Cardaz. So this idea that the people should have the burden of proof that he will reoffend, that's just not what the current case law from the Supreme Court says. So unless there are further questions, the people would rest.
Can you address Shannon? Because I know you supplemented with respect to Cardaz, which we appreciate, but then Shannon came out as well. So can you speak to that a little bit?
Yeah, so Shannon is multiple counts of CSC 4 from my understanding, but I would argue that, the Court of Appeals has not indicated that or the Supreme Court has not indicated that a tier 3 offense, which is what this is, whether it's attempt or not, this is still a tier 3 offense. And those are the most, the
Tier 3 is pretty capacious, though. I mean, Cardaz said that. It covers a wide range of offenses. So, and I understand that's the statutory classification, and I don't think there's any argument being made that this is, that the registration attaches by statute. But I think that the question is constitutional implications of that. The statute captures so much within this tier 3. Are there constitutional implications that arise from that with respect to certain individuals, whether it's a category of certain individuals or this one in particular?
Well, I would argue, Your Honor, that because of the nature of the age of the victim, she was, I believe, 11 years old in this case, and the predatory conduct, that even for this defendant, whether or not he accomplished the act, it is egregious. It is something that will impact this child for the rest of her life. And whether or not he actually accomplished it, making it, elevated to actual touching or penetration, he was convicted of attempted CSC 2, but I would just argue that registering for this specific defendant, given the nature of the probation violation 2, which although there was not touching, there was a record made in the lower court that he was attempting to represent himself as a nurse so that he could access the diaper of a small child and review the child's genitals. So the fact that an individualized assessment has not been provided, does not give this court doesn't have the ability unless it deems CSC 2 unconstitutional as a broad analysis. It does not have the ability, based on the current case law, to make that ruling without creating new law. So, are there any other questions?
No, thank you.
Thank you, Your Honors.
In defense counsel, you are out of time. Unless there are any questions from the panel for her.
No questions.
Okay, great. Thank you,
Thank
counsel.
you.
That matter will be submitted. Okay, moving on to item number 16, case number 370749, People v. Thompson.
Good morning, Your Honors. Chloe Bruick from the State Appellate Defender Office on behalf of Mr. Jason Thompson. Your Honors, I'd like to focus my argument today on the first issue in the brief, the insufficient evidence issue, and I'll rest on the briefing with regard to the others, subject to any questions, of course. Mr. Thompson is currently serving 25 years in prison based on a conviction that was obtained despite huge holes in the proofs and minimal insufficient circumstantial evidence. The evidence that was used to convict Mr. Thompson as the perpetrator of an armed robbery was that he was walking in the parking lot of the hotel he was staying at. He dropped money on the ground and was wearing similar generic looking clothes as the robber. And I have 3 points that I'd like to emphasize to the court with regard to this issue. The first point is that no one identified Mr. Thompson as the perpetrator of this robbery, and there's no physical evidence that linked him to this robbery. The one really identifying piece of clothing that was attributed to the robber was the red sweatshirt, and that was not attributed to Mr. Thompson. The second point that I'd like to make is that the circumstantial evidence here was insufficient to prove beyond a reasonable doubt that Mr. Thompson was the one who committed this robbery. The sole issue at trial in this case was identity. And there's two, I think, categories of information that the prosecutor used, and that was the clothing Mr. Thompson was wearing later in the night and the money that he dropped on the ground. And I'll take each of those in turn. First, with the clothing, we have this really incredibly generic clothing. We have blue sweatpants, black shoes, black boots, and a gray sweatshirt. None of these clothing is particularly identifying. They're not bright. They're not patterned. I think it would, of course, be a much different story if maybe we had branded clothing, but we just don't have that here. And a gray sweatshirt, blue pants, and black boots aren't enough to get us to this definitive issue of identity beyond a reasonable doubt that it was Mr. Thompson.
I mean, counsel, you are at the, insufficient evidence obviously is
Of course.
it's a steep hill that you're at the bottom of, and you have to draw all reasonable inferences in favor of the verdict, right? And
Of course.
it's not whether there are, arguments for how you could conclude differently or maybe have doubt about the jury's verdict. So I guess, I understand your points about we don't have the physical evidence. We don't have, a eyewitness that says, yeah, that it's that guy, but we have a fair bit. So what is the clear legal deficiency that says the jury could not have done this in a way that is legally reliable?
Sure. I think besides, of course, in our opinion, Mr. Thompson's position, that this circumstantial evidence was simply insufficient, I will say that I think that the thing that really gets us there and that would be a much different story is the fact that we do have these really clear videos from the Red Roof Inn that depict the robber earlier in the night and then Mr. Thompson later in the night. And there's two points I want to hit about that, about the insufficient evidence. First is that when Mr. Thompson is walking in the parking lot later in the night, it's the same camera view that we see of the robber earlier. Mr. Thompson turns into the building and into the Red Roof Inn and goes back to his room. The robber earlier in the night does not come from that same place. We have no clue where the robber came from when they walked from the back through the parking lot. And the second point is related, I suppose, to that, and that's that we have despite the testimony that we have 32 different camera channels of these really clear videos from the Red Roof Inn, the fact that we have no idea either A, where the robber could have come from earlier in the night, or Mr. Thompson. And the fact that we don't have those leads to this huge just gaps in the proofs, that the fact that we have these specific videos and that it shows the missing gaps that was needed to get there to identity. And so the circumstantial evidence is simply too many leaps to get to the inferences that we need to get to here. And so I think, just to answer your Honor's question, the missing and legally insufficient portion is the fact that we have these videos and we don't have the complete story.
Well, you're talking about the clothing, but also the face could be seen of the person that is being identified as the robber. And he had a beard, and apparently he had, the video shows someone with a distinct nose, flat nose. So there's more than just the clothing going on, correct?
Yes, Your Honor, there is the testimony about the beard, and I will say in response to that, the only video we have of the beard is the robber walking through the Griffin Claw parking lot. It's really quite blurry. When the exhibits of the prosecutions that were put of the comparison photos with Mr. Thompson's mugshot, I mean, I don't know how we can get to these are the exact same thing. It was a black man with a beard, and it's just insufficient evidence to get to the issue of identity.
But he is seen shortly after the robbery going back into his hotel room, correct?
Correct, a half hour later. And of course, the robbery was a half mile away. And it's not in dispute that Mr. Thompson was staying there through Lighthouse, the Oakland County Homeless Shelter Program. And of course, you know, people in transitional phases could have cash for any types of reasons. But unless the court has further questions, I'll reserve my time. Thank you very much.
Thank you.
Thank you.
Good morning, Your Honors. May it please the court, Joseph Shada on behalf of the people. I'm going to primarily rely on my brief, but just want to emphasize a couple quick points here. It is not just the clothing here. In addition to the clothing, it's the timing. As Judge O'Brien mentioned, it's the fact that he's dropping wads of cash as he's walking back to his hotel room after the armed robbery in which cash was taken. The red sweatshirt was found in a ditch along the path back to the hotel. So it's all of these things combined that provide more than sufficient evidence in this case. And with that, I'd rest on the briefing, but would be happy to answer any questions that the panel may have.
You know, there does seem to be at least one piece of potentially exculpatory evidence here, which is that if this person had just robbed this gas station and police are on site, you know, and speaking with staff up front, why would he go into the lobby when the police were in there?
Could you repeat that?
If this, I guess the exculpatory evidence potentially would be if this individual had just committed a robbery at the Speedway, right? And police are at the Red Roof Inn, well, at the let's say motel, interviewing the staff there about that robbery. Why would he walk in the lobby while the police were there?
Well, police Detective Reckling to collect the video didn't show up until after the fact. The police initially responded right to the Speedway, and then
So you're saying that he was in the lobby speaking with the staff about, he meaning the defendant was in the lobby speaking with the staff about certain items, and that's when the police walked in? Let me explain what I'm saying
Sure.
here again. Why would somebody who had just robbed a gas station, knowing that the police were in the lobby of the hotel he was staying at, you know, inquiring about the gas station robbery, why would he go into that lobby?
Oh, I don't think he knew the police were there. That would be my answer to that, if I'm understanding the question.
Well, were the detective, was it a plainclothes detective? Were there uniformed officers there for that investigation in the lobby? I mean,
don't know if it was plainclothes or uniformed officers, but by the time Detective Reckling was there to speak with the hotel employees, it wasn't until I believe the 25th, and this occurred in the early morning hours of the 23rd, if I have those dates correctly.
okay. So in other words, he didn't realize the police were in the lobby.
Correct.
Okay.
I have a question. It really doesn't have anything to do with this outcome of this case, but Detective Reckling, did he tragically?
He was killed in the line of duty,
That's
yes,
what I
in an
thought.
unrelated
Okay.
case,
Yeah,
correct?
it's very sad.
Yes.
Yeah.
Brother? No. Okay, thank you, counsel.
Thank you, Your Honors.
Any rebuttal?
Your Honors, I have nothing further unless you have any other questions for me.
Well, what about the issue we just talked about? Is
Yes.
there any, what would your position be with regard to when your client walks in there when the police are speaking with the staff about the robbery? Did he know they were in there? Like, there's nothing in the record that really tells us any of this?
Your Honor, I don't know that there is anything in the record that can speak to the plainclothes and things like that, or whether my client knew that the police were there. But I agree that it's exculpatory. Mr. Thompson walked into the lobby to ask for some items and the police were there. If he had just committed an armed robbery, I don't know why anyone wouldn't have just turned right around and not asked for the items. So I agree with Your Honor that that is exculpatory evidence. Mr. Thompson would not have stayed in the lobby if he had committed this robbery. So I'd ask that Your Honors reverse and remand to vacate the conviction. Thank you.
Thank you.
Thank you.
Okay, that matter will be submitted. We'll move on to item number 17, 371-552, People v. Giles. I believe we have counsel for appellant appearing remotely. Good morning, Mr. Strauss.
Finally, okay. Getting better all the time. Good morning, Your Honors. We have the one issue here is
Can you place your appearance on the record, please, just formally?
I'm sorry?
You just place your appearance on the record, please.
Oh, Gary Strauss on behalf of defendant.
Okay, thank you.
Okay. We only raised one issue in this case. It's ineffective assistance of counsel. And I'm sure the court is familiar with the briefing. The defense counsel, for really no discernible reason, opened the door to this unproven incident where Mr. Giles allegedly had stabbed Mr. Bigby in the face a week or so before. And the record shows that the prosecutor had no intention of bringing up this alleged attack. There was no 404B notice. Basically opened the door, and in some ways even used it as prosecutor even used it as propensity evidence. And there's really could be no discernible strategy in this questioning about the stabbing. Counsel kept going on and on, trial counsel, about that, asking him where he was stabbed, and it seemed at one point he was kind of asleep at the wheel. He asked him where he was stabbed. He said, "In my neck." And I started kicking him with my legs. And then trial counsel asked him, how would he be kicking you in the leg when you're in the car? But he said that he was trying to kick him outside the open window. He asked him how many times he was stabbed, the name of the hospital. And Bigby answered all those questions. The only thing he was a little foggy about, because they were all very drunk, was precisely what they were arguing about in the car on the way to that gas station. And the evidence wouldn't have come to light in any way if he didn't go into that.
Mr.
Now-
Strauss, don't you think, I mean, I agree with you, it is unusual that it was brought up, but don't you think it was part of defense attorney's attempts to attack the credibility of Bigby? He was trying to show that he wasn't a truthful person, like you claiming he stabbed you, but when it first happened, you said you didn't know who was involved in this shooting, and now you're telling us that this is someone that, a month earlier stabbed you in the neck, and why didn't you go to the police about it? Don't you think he was trying to attack the credibility here?
Well, Your Honor, that's what the prosecutor brings out in the brief, and I'm sure she will express the views fully here. But no, he didn't use it for that purpose. He didn't mention it on opening. Maybe you could say he was a sneak attack there, but he was aware of what happened before, or should have been aware of what happened before. I don't know if he ever examined the victim, who had a scar running all the way down his face. And then if you talk about impeachment, I don't know if this is hindsight, but I guess every examination of this court for ineffective assistance of counsel is going to be a hindsight review. It has to be. But he didn't attack anything. Prosecutor said, well, in his closing, he referred to that. He really didn't. The only thing he talked about was he couldn't even tell me what they argued about. He went into detail about what happened. And as far as that goes, and it wasn't reported to the police, but contrary to that type of argument, they had to really kind of strongly compel Mr. Bigby to testify at trial. The court's aware of that too. So he didn't want to be there and get involved in that because, of his social circumstances and being involved in that thing. So there was really no purpose for it. And if the court believes that you can't tell, just because something goes wrong doesn't mean it's ineffective assistance of counsel, that would be true in every case, in every single case with ineffective assistance of counsel. But here it was devastating. And to say that it wasn't harmless or the result wouldn't have been different, that can't be true because he was up for assault with intent to murder and also assault to commit great bodily harm. And the difference in the guidelines there is pronounced. As a fourth habitual, he got 25 years for the conviction. And as a fourth habitual, a Class D felony for assault with attempt to commit great bodily harm, the guidelines were 34 to 134 months. So it's, quite a large difference. And again, I can't, on the record, I can't discern any possible strategy in asking those questions. And then, of course, the prosecutor, who never intended to introduce that evidence, probably because it would cause an instant mistrial, plus there was no 404B notice filed, even had him stand up and show the jury where the scar on his face was. And to think that wouldn't affect the jury's verdict, that would be absurd because it's pretty devastating evidence, a lot worse. Now, this case, the main case, of course, was being shot in the foot, but that could be defensible in some ways. And of course, Mr. Giles maintains his innocence. But even with that, I think there's very strong grounds to believe he wouldn't have been convicted and certainly deserved that chance. And the prosecutor stated, given the strength of the evidence, there's no reasonable possibility. Strength of evidence for what? With intents to kill. And then the prosecutor, of course, in closing was saying he finished the job. And if that's not propensity evidence, I don't know what is. But I mean, counsel opened the door for all of that. And again, if you have any questions, Your Honors, I'd be glad to answer them. But I can't discern any reason for him bringing that up.
Well, let me ask you this. So if defense counsel had instead asked questions where he's basically challenging the witness's testimony about identity, I mean, isn't there a pretty good chance that the prosecutor is going to come back on rebuttal and ask the witness about this prior incident?
I think it would have been well, first of all, would have to file a notice under 404B for other acts. And I don't know what his purpose would have been, but we don't know that because he didn't file that, didn't mention it in his opening statement, and neither did defense counsel. And it was a very lame closing. He really had nothing to say.
But you in your practice have seen plenty of transcripts where even though no notice is filed, the question gets asked anyway, particularly when it's in rebuttal. I think you can agree with that.
What, the question from the prosecutor?
Yeah.
Well, it was only in play because of counsel's error.
No, I'm getting back to my hypothetical. So if instead of doing what defense counsel had done here, if instead he had just asked questions challenging the witness's testimony that pertained to the identity of the shooter, if he had done that, wasn't he running the risk that even though no notice was filed, that the prosecutor was going to inquire about that prior incident on rebuttal? Because we see that all the time, don't we?
I've never, you've probably seen a few more cases than I have, but I've done hundreds of cases and I've never seen that. I've never seen anything like this before. I mean,
so I guess one potential answer to that though, are you saying that
I'm losing the sound here? Wow,
I'm
boy.
sorry.
Oh, Jesus Christ. Oh boy.
Your microphone's still working. Can you hear me?
Yeah, the sound went out.
How about now? Can you hear me now?
Yes, yes.
Okay. So is one potential argument here that essentially defense counsel should have just asked no questions? In other words, the prosecution gets done with their examination, and in order to not open the door to all we've discussed, you simply say to the court, I've got no questions for this witness. And then none of it comes in,
I don't
right?
know Your Honor, I don't know if that's incumbent on us to write what I would have done on cross-examination, how we would approach anybody else would have approached the case, but it's certainly not like that. That's playing with dynamite. I mean, he had a scar. I mean, maybe his sight is not very good even during trial. Before I brought it up, he's looking right at the man. I mean, to bring that up, that he's going to make that up. He got stabbed in the face by somebody else. I mean, there's got to be some rationality brought into this process. I don't know what he should have done on examination, but as you can imagine, this is a court-appointed case. You have a lot of very, very hard cases. So I don't know how sometimes you think that sometimes you might look back and be critical and think, oh, defense counsel was phoning it in. You know, we had nothing to go on. Here, he just turned the tables completely on his clients. I mean, I can't see a good outcome of that. What was the credibility? No stab wound. He didn't talk about identity at all. He just talked about, hey, you didn't remember what the argument was about. He admitted he was drunk, so that would have gone absolutely nowhere. I mean, I don't remember arguments that I've had 2 or 3 years ago, and I don't drink, but that would make it a little more difficult. So again, there's really no purpose for this. If this isn't ineffective, I don't know any circumstances that would be.
Okay, counsel, I think we understand your position.
Thank you.
May it please the court, Deborah Blair, on behalf of the people, the Wayne County Prosecutor's Office, the appellee in this matter. The defendant raises one issue in his brief on appeal, that is that trial counsel was ineffective when he questioned the victim about a prior attack by the defendant. The record shows that the defense attorney was attempting to show that the victim's version of events was unworthy of belief because of the strange circumstances in this case. It is strange that the victim would claim to be stabbed repeatedly by the victim and not report it. Then even when shot by the defendant, not want to cooperate with the police. And then there is also the fact that there was testimony about allegedly the victim had asked for a bribe from the first defense attorney, Mr. Nyhouse. So this was a tough case to defend due to the strength of the people's evidence. So this was one strategy that defense counsel engaged in to try and discredit the victim regarding the events that occurred on October 17th, 2021. When looking at the prejudice prong in light of the strength of the people's evidence, there is no reasonable probability of a different result. Given the video at the gas station, the lineup identification, the car being registered to the defendant's wife, the car being seen on the surveillance video, the car being a unique purple Ford Flex. The defendant wore the same clothing when he was arrested as when he engaged in the shooting. So, and other evidence leads to the conclusion that the defendant cannot show prejudice, even if we were to conclude that it was improper to question the victim about the prior event with the defendant. Other than that, I will rest on my brief unless there are any questions.
No, thank you.
Thank you,
Thank
counsel. Mr. Strauss. Any rebuttal?
Yes, Your Honor. As counsel just brought out, the issue, the issue here revolved around intent. And from my perspective, they had evidence, and I didn't raise sufficiency myself that he didn't shoot anybody, he wasn't there, nothing of that nature. It's all about intent. And the fact that he didn't report it and had to be threatened with jail time and was tethered and had to show up, that inures to our benefit, you know, showing That's why it happened, so you couldn't impeach anybody on that. He should have been aware what he had gone through to get him to testify in this case and the kind of neighborhood he lives in and why people don't snitch because nobody's going to, give him security like somebody in Congress, around the hour. It's not going to happen. So that's why he didn't report it. He wouldn't have even gone to trial and just lived with the circumstances that he's dealing with. So, the fact that it wasn't reported, oh, and I'm sorry, let me back up now. And with intent, after he brought up that evidence, the prosecutor mentioned more than one occasion, yeah, he finished the job. Now, how could he have done that? That's propensity evidence. How could he have ever done that if he didn't open that door? I mean, this was just devastating. So if there's any questions, Your Honors, but I think this is clearly ineffective assistance of counsel. And it's not whether he would have been acquitted or not. There was no evidence that he was there. It's what his intent was. Was it to murder him? He could have, to finish the job. Why didn't he finish the job then before? And this evidence that shouldn't have come in. I mean, I would just ask that the court, at a minimum, remand. We filed a motion for remand it so counsel could explain his strategy in this case. I think he'd have a difficult time doing so, or just reverse the vacate the opinion and send it back for a new trial.
Okay, thank you, counsel.
Thank you.
Okay, thank you.
All right, that matter will be submitted. Okay, moving on to item number 18, case number 366-478, People v. Willis.
Good morning, Your Honors. Emma Lawton from the State Appellate Defender Office on behalf of Melvin Willis, and Mr. Willis's family is in the courtroom this morning.
Okay, welcome. Before you start, counsel, I know we have an appeal, we have a cross appeal. Are we just gonna do everything at once on both sides, or?
That was going to be my question. I don't usually ask a question of the court, but as it relates to the appeal, I intend to rest on my brief and spend my time for oral argument on the cross appeal, which is the conflict question. And so I don't know if the court prefers to hear from the prosecution first, or since technically they're the appellant there.
We'll just, why don't we take the appeal and then we'll take the cross appeal? How about that? So why don't we start with your appeal? You plan to rest on your briefs?
Yes. Unless the court has questions.
Any questions on?
No.
Okay, so why don't we hear from the prosecution?
Thank you, Your Honors. May it please this honorable court, Gabrielle Ragland on behalf of the people as to the appeal. My colleague, Ms. Armstrong, will be dealing with the cross appeal. I do just have a few points that I would like to touch on in response to Ms. Lawton's brief. Obviously, if the cross appeal is successful or unsuccessful, that may change the calculus a little bit, but I will again focus directly on the direct appeal. So the first thing I wanted to touch on was issue number 1 regarding the prosecutor's duty to disclose statements that Ms. Shana Moore made during a conversation with the prosecutor. I do think it's important to this court to provide the context that when Ms. Moore met with Prosecutor Danner inherited this case, and he represented to the court that this was in the course of trial preparation. And I will note that I did see in the responsive brief that there was an argument regarding mine, stating that the Miranda analysis for the purposes of MCL 7638 is not applicable. However, this analysis, the Miranda analysis, whether or not Ms. Moore was in custody, was an analysis that was used by this court in People v. Timms. That's an unpublished case with docket number 344222. It's the people's position that Ms. Moore was not in custody for purposes of custodial detention. She was arrested. She was in leg shackles. She did appear at the prosecutor's office. However, she'd already been pled to the conspiracy and other life matters at this case and was awaiting sentencing. However, due to the totality of the circumstances, what was going on between Ms. Danner and the detective in the prosecutor's office was an interview. It wasn't necessarily a custodial interrogation. Regardless, the remedy of not having that statement recorded is present in the statute in 763.9. The remedy is not suppression. The remedy is not suppression or a new trial, as Ms. Lawton has indicated in her brief. The remedy is a specified jury instruction indicating there should have been a recording, and that's if this court determines that this was a custodial interrogation. So that is a point I wanted to touch on. The second issue I wanted to speak on was issue number 3 regarding Officer Yeager being a non-expert lay testimony. And I did just want to note something. There are a few cases that are unpublished that are very specific to the point of whether or not cell phone specific data or interpretations are considered in the purview of an expert or considered in the purview of a lay witness. Detective Yeager did not perform any particular analysis. He received the information, fed it into a program, and showed that program on a map. He did indicate like this is how a cell phone tower works. And I will quote from People v. Breyer, which is also unpublished by this court, and that is docket number 343234, when it says, as cell phones have become, and this is on page 4. As cell phones have become common devices used daily by virtually all members of our society, the technology of the cell phones increasingly has entered the realm of common knowledge. It seems fairly certain most members of the general public are aware of the location of one's cell phone is continually tracked and recorded, which undermines Ms. Lawton's claim that the knowledge that towers exist or can be transferred to a cell phone is not a matter of common knowledge. And this analysis was also used in another unpublished case, People v. Flowers, which is 353346 and came out in 2022. Other than those 2 points, which were raised more on the response or in the reply brief, I rest on my brief.
I'd like to ask you about the issue you didn't address.
Oh, perfect.
Which is the 404B one.
Certainly.
So that's because that issue concerns me. It seems like there was evidence that came in regarding, and this is, I think, framed in an ineffective assistance of counsel way,
Yes.
regarding past conduct between these 2 individuals, the defendant and Miss Moore. Basically, that this is what they do.
Yes.
And it does not sound like that evidence was noticed for introduction at trial, and that was not the plan for it to be introduced. Sounds like defense counsel brought it out, and the transcript does not particularly support the idea that this was a very informed decision. So, and it seems important to me, the difference between the evidence of just this incident and the evidence of a pattern of conduct of which this incident was a part seems like an important distinction. So tell me why I should not be concerned about this issue.
Absolutely, Your Honor. So introducing the 404B issue, which I believe was the conduct that Ms. Moore and Mr. Willis had this plan of sort of honeypotting other people, saying they'd meet them in the parking lot and then robbing them. So I foresee, and obviously I am not in trial counsel's mind, I can't psychically guess. The purpose of introducing that evidence was to show that there had been poor and slipshod investigations between the police officers, that this had been a recurring incident and they weren't properly investigating it. But even the testimony that there had been a prior robbery, the investigation was relatively incomplete. All that was placed in the police report was these are the gender of these 2 people, the race of these 2 people, and it happened in this parking lot. It was my understanding defense counsel was trying to basically muddy the water and argue that Miss Moore is a liar. She did these robberies with her brother, not Mr. Willis, and that the police were poorly investigating these series of robberies. Now, I don't think that worked. I don't think that they came across that way, but I do see that there was a trial strategy.
So it needs to be a reasonably informed strategy, though, right? I mean, you can say this is my plan, but if it's not based on good information that you should have discovered informing that plan, then that's a problem too, right? And it seems like from the record, he's talking about hearing about this second robbery for the first time. This does not seem like a well-cooked plan, regardless of whether it worked out.
Right. I would concur with you. I don't think that that was a well thought out plan. Specifically, it's not my
That
reservation.
seems deficient then.
Well, Your Honor,
I mean, if it's a
don't.
not well thought out plan is different than a plan that just doesn't work out.
Yes, Your Honor, I would agree that a well thought plan is different than a plan that doesn't necessarily work out. However, I would fall to the next prong of that analysis is whether it actually prejudiced the defendant. Again, these police reports that came out don't necessarily say that it was him who did it. We do have other credibility issues with Miss Moore that's been stated back and forth between the record. I also believe that there is other sufficient evidence. I don't see how this would have specifically prejudiced this defendant to the point where a new trial would be necessary or more significant information would be needed in like such as a Ginther hearing to explain why specifically he asked this.
Okay, any rebuttal, counsel?
My reply brief addresses People versus Timms, and there's also a citation in my reply brief to, I believe it's People versus Al-Hawi, which talks about cell site location information and the fact that it is not easily cognizable to the layperson. Regarding the 404B issue, though, I would just want to draw the court's attention to specifically the exchange between Mr. Burkett and Detective Reisenen, which really does show the lack of investigation here, which is that Mr. Burkett is putting on this show in front of the jury to say, look at this investigation. They didn't give it to me. They didn't show it to me. And Detective Burkett says the police report's right here. We gave you these police reports.
It's in the discovery packet.
It's in the discovery packet. It's report number 25. There's a lot of reports that came after it. We've been giving these to you sequentially. And that's an ongoing problem with Mr. Burkett's representation of Mr. Willis throughout this entire trial is that Mr. Burkett doesn't even know when the prosecution has rested and he started presenting his defense. He shows up the next day and he's surprised that the prosecution isn't calling witnesses, and it's Mr. Danner who has to say to him, I rested yesterday, and that's why you called a witness yesterday. Mr. Burkett does not appear to be paying attention to very much of what he's doing in this case. And as I'm sure we're going to discuss in length as it relates to the cross appeal, that ties into Mr. Burkett's conflict issues and his deficient performance throughout his representation of Mr. Willis.
Can you speak to harmlessness? I mean, so deficient, let's say I agree with you, deficient trial strategy. How do I know it? There's a reasonable probability that at least would have made a difference.
I think there's prejudicial harm here because the jury is hearing that they're hearing unreliable evidence, right? That this was Mr. Willis. The prosecution concedes there's not much to tie Mr. Willis to this other robbery. But that's not what the jury is hearing. What the jury is hearing is that someone else who drives a car like Mr. Willis committed a robbery in the same parking lot where this shooting took place. And that sounds like a pattern of behavior, right? That matches up. It corroborates Ms. Moore's testimony that we've done this before. It corroborates Ms. Moore's testimony, I believe, when she says we did this in the parking lot before, because part of the reason this starts coming out is because Mr. Burkett is saying to Ms. Moore, well, tell me about the other times, describe the other acts that the two of you committed. And then he wants to put on the show if the police didn't investigate it, the police don't know about this. And then the result is that Detective Reisenen says, actually, we did investigate that. Actually, we do have police reports. Actually, we can show that robbery took place and that person reported it to the police, and we just can't tie it to Mr. Willis. And that, I think, is very damaging in evidence in a case where the defense is Ms. Moore's credibility.
Understood. Okay, let's move on to the cross appeal.
Good morning, Your Honors. Fawn Armstrong on behalf of Plaintiff Cross Appellant from the Washtenaw County Prosecutor's Office. This is just about the cross appeal, about the new trial that was granted. First, we do believe that this court should reverse the trial court's order granting the defendant's motion for a new trial. We cited primarily to Culver versus Sullivan,
a SCOTUS case and which holds that that the defendant, to prove his Sixth Amendment right was violated by multiple or dual representation, he has the burden to establish, one, that there was an actual conflict of interest, and two, that that actual conflict adversely affected his lawyer's performance. But at that hearing, and in the pleadings, the defendant did not meet either of those prongs or his burden in this case. As to the actual conflict, we explained that the interests were essentially aligned. Both of them had motivation to have the same story presented, that he was with his mother the entire time, Mrs. Fuller. And as to the actual, or so the
Is
adversity.
that enough? Just because they would both like him to not go to jail? I mean, is that enough to say their interests are aligned as clients, that there's no conflict?
I think that's one of the things. I think that our brief discussed several other ways to show that there was not an actual conflict. But so that's one thing to point out, that there's not an actual conflict, that their interests are aligned, but their interests also never diverged at any point. And I think that's also an important distinction.
Well, could it be, I mean, wasn't there I guess there's a question, for instance, of whether to call her as an alibi witness, right?
Sorry?
There's a question of whether to put her on the stand as an alibi witness.
Yes, that is that is something that they
So
have
are
considered.
those, tell me why there aren't potentially divergent interests in what, Mr. Willis's counsel may see in his client's best interest there, and what Ms. Fuller's counsel may see as in her best interest there, particularly given the pending charges that she has and the apparent arrangement that we don't know the full specifics of, but at least does seem tied to the disposition of this case and potentially the nature of the testimony that she offers.
Well, I believe, to me, a lot of that falls more under the adversely affected the performance. But in this, so along with that goes with, first, I want to point out that there were 2 other alibi witnesses presented. And even with those 2 other alibi witnesses, the jury still convicted.
But neither could put him exactly where he said he was, right? I mean, the alibi was he was with Ms. Fuller, right?
Yes, Your Honor.
So, we have 2 other alibi witnesses that kind of dance around that a little bit, but we never actually get anybody saying, yes, that's where he was. And presumably Ms. Fuller would be the person who could say that.
Yes, but we also don't know, because there was not a Ginther hearing, whether or not Mr. Willis and Ms. Fuller agreed to waive any potential conflict. If they had a conversation about this, if they both agreed at some point or another that Ms. Fuller should not testify on Mr. Willis's trial. So there's just more that was not fleshed out. But again, it's not our burden to prove the actual conflict, it's theirs. And as to her being called as a witness, they have only presented, we believe, speculation that the decision not to call her was only to protect her. That could have been one of the reasons why, because she does clearly have Fifth Amendment issues. But
With
it
respect to
also,
the alibi? I mean, I understand your point with the Fifth Amendment with respect to the jail calls, because it seems like that's what the criminal charges were based upon for her, right?
yes, the jail
Witness
calls.
tampering,
And-
with respect to the jail calls.
Mhm.
But I don't know if why would the Fifth Amendment necessarily attach to the alibi testimony? Like, what Fifth Amendment implication is there on that piece?
Oh, I don't think that would. So how I
Okay.
picture that going down is that
Yeah.
defense calls Ms. Fuller, she presents her testimony, which again, I would argue is not credible, but she presents her testimony, and then on cross, right, she's asked by the prosecution about these jail calls, and now she pleads the Fifth. And that could adversely affect the jury's opinion about her entire testimony if they were to believe and have some sort of credibility on her testimony about the alibi. So that could adversely affect the defendant's entire defense.
But isn't there already testimony in the record from the police officer about, well, here's what she told me, but I didn't believe a word of it. I mean, how does that credibility get worse by putting her on the stand? It sounds like it's already pretty thoroughly impugned by the officer's testimony.
I think that juries, I think it's very reasonable to assume that a jury seeing somebody plead the Fifth makes them look like they have something to hide and makes them feel or seem not credible. And so that they might have been able to, at that point, disregard her entire testimony based on that. Okay. So again, they presented speculation only. The decision not to call Fuller was only to protect her, and that this strategy actually harmed his defense. And we don't believe that this conclusion is supported by the record. At first, the defense is unable to overcome the strong presumption that a decision to not call Fuller or any witness is sound trial strategy. And the defendant's or defense counsel's decision not to call Fuller does seem by the record, supported by the record as a strategic reason. So one, we already brought up the Fifth Amendment issues. Two, there could have been an implication, like in the unpublished case of Howard that we also cited, that they were related. So the jury might say, oh, this is just a mother trying to protect her son. She's lying to protect her son. So the jury could not have perhaps believed all the alibi witnesses if they were feeling that at least one of them potentially was lying. And also she was not likely to appear credible to the jury just based on the testimony and all the other evidence that was presented. During her interview, she changed the times that the defendant arrived at her apartment during that police interview. So she was inconsistent with her story to the police.
Those all may be reasons why you don't, why the alibi defense maybe isn't a great one, but it's nonetheless the one that was offered at trial. So I guess the question is, if you're going that route,
right?
Is there really that strong a reason not to at least put her on the stand from Mr. Willis's perspective, not from hers?
I see that, but I really can't see with all of the issues that her testimony would produce, why it would be strategic to put her on the stand. Because not only is she inconsistent with her testimony, she almost contradicts another alibi witness because she doesn't mention they're apparently there at the same time at this location, another alibi witness, and she never mentions to the police at any time that person was there. And her tower evidence, her cell phone tower evidence, contradicts her statements. They're in two different locations. There's also this statement, she at one point even called the defendant and he didn't answer. And that was during a period of time that they were supposed to be together. That was going to be her testimony. That was what she was telling the police. They were there together from this whole period of time. So that could have hurt, I think, the credibility of the other alibi witnesses because she was just going to be so uncredible with her testimony. Because her testimony specifically could be controverted with other evidence, which they didn't really have with the other witnesses. And one of the other things I wanted to point out is that, we don't really have to speculate too much about whether defense counsel's decision was strategic or not, because the defendant himself at sentencing placed that on the record. He said he was complaining, I believe, at sentencing about having disagreements with defense counsel. And he said he was advised by counsel that he would be convicted if he called certain witnesses, including his mother. So we already know that this was a strategic decision based on the defendant's own words. And that was at sentencing transcript page 8.
But again, it may have been a strategic decision, but
yes,
it's a matter of like in whose interests it was, right? So counsel could say, I've made, I don't think this is a good idea for you, but the question is whether that was impermissibly tainted by the dual representation, right?
I don't believe so, because I don't believe that any attorney, so say if there's another attorney that represents Ms. Fuller and another attorney, and so separate attorneys at that point, that attorney, any effective attorney would have advised Ms. Fuller to not testify at Mr. Willis's trial. It's very clear that she had her own pending criminal cases or criminal felony offenses that were still open. So I don't think that it shows that there's it was his decision adversely affected the defense. I just don't believe that they can meet that burden and prove that, because in looking at the alternative, she would never have been advised to testify reasonably by an effective attorney. One thing I also wanted to point out too is that we don't believe that the trial court followed the Collier approach, the reasoned approach, the two-prong approach. The court seemed to only treat it as any multiple representation is a per se violation. And so we believe that she presumed both prongs without having actual record testimonial evidence, which is required under this standard. So multiple representation of co-defendants is not a per se violation of the Sixth Amendment, and Melissa and Fuller were not even real co-defendants or had their cases joined. A conflict is never presumed or implied, and in Collier, it specifically stated the attorney's representation of multiple clients is presumed constitutional. Again, it's the defense's burden to show that there is an actual conflict and it adversely affected the representation. And I would ask the court again to focus on that unpublished case, People versus Howard, issued April 11, 2017, 320695. That one is very analogous to the facts in this case. And I think it's very important to see that one. And as this court have found that the defendant in that case had failed to overcome the strong presumption that the defense counsel's failure to call a co-defendant as a witness constituted sound trial strategy. And in that case, there was a Ginther hearing and the defense counsel actually testified. He didn't call the brother, the co-defendant, who testified because he lacked credibility. He refused, he wanted to testify that his brother wasn't the shooter, yet he refused to identify who the shooter was. He admitted he was there, but wouldn't say anything else about that. So the defense attorney was very concerned about having that testimony because he believed that would affect the credibility of the two other alibi witnesses that were presented. But also, the attorney didn't call him because he believed that the jury could potentially not find that brother credible because they're related, they have a motivation or a bias for that person, and they could have been lying just to protect the other brother. And so he believed that it would be better strategy to not call the brother at all. And we believe that's very, very similar to what happened in this case as well. And I would lastly just like to say that if this court does not agree that the court should reverse the trial court's order and granting the defense motion for a new trial, we would ask that the court then at least vacate that order and remand for a Ginther hearing so that we can get a lot of these questions that your honors have had today on the record. And when we can ask the defense counsel why exactly he decided to not call Fuller. What conversations did he have with the defendant about it? Were there any discussions between the defendant, Ms. Fuller, and the defendant himself about the multiple representation, the potential conflict of interest, all of those things? Did defendant and Fuller both voluntarily and knowingly waive any potential conflict of interest? At what point, at any point, did the defendant agree that he shouldn't call Fuller? Was there an agreement with the prosecution to dismiss Fuller's case only if he was convicted, or if there was just a general statement that they would potentially dismiss it regardless of the outcome of the trial just after the trial was over? And then also we could potentially call Ms. Fuller at this Ginther hearing and see what her testimony would have been, and if she actually did want to testify regardless of potential self-incrimination issues, which is something that we don't have, I believe, in this case, whereas in Howard, they had an affidavit from the brother with what he would testify to. So thank you. Any other further questions?
Nothing further.
Thank you.
Thank you, counsel.
I want to start with the distinguishing factor in Howard, which is that Mr. Howard's attorney did not call the officer in charge of the case against Mr. Howard as an adverse defense witness and then question him about statements that Jermaine had made to him while the detective testified Jermaine was lying to me. That's what happens in Melvin's case. Defense counsel does not call Melissa. He proceeds with an alibi defense that Melvin was with Melissa. And then he calls as a defense witness the officer in charge, and he elicits Melissa's out-of-court statements from a police interview. So when Judge Kunke ruled that there was a conflict within the definition of Kyler here, which means conflicting interests and an adverse effect on the defense, she's ruling based on record evidence that defense counsel performed deficiently. He clearly wanted these statements by Melissa in, because he calls Detective Reisenen and asks him to describe Melissa's out-of-court statements. These statements are not admissible. There's no impeachment. There's no hearsay exception to admit a different person's police interview as evidence in a case. But that's what Mr. Burkett does. He calls Detective Risen in and he questions him about what did Melissa tell you? And as Detective Risen answers those questions, he says, Melissa's a liar. I don't believe her. She lied to me the entire time she talked to me. The lie was that Melissa, that Shania, and he describes the whole thing, right? And he says, all of this is a lie. So we don't need a Ginther hearing to determine that that was unreasonable.
Now, I guess what the counsel's point of that, well, putting her on is just going to make it worse. Like it maybe counsel's judgment is, I understand that the police officer is going to come up here and say that she's lying, but we can get in what she said. And yeah, we're going to have that damage. But obviously, of course, the police don't believe her because here we are. So what if the theory that this actually is perhaps the least damaging way of bad options to get this testimony in front of the jury?
I think my first answer to that is I just don't think that is ever going to be an effective way to present an alibi defense. At the point where you are presenting the alibi defense, I don't think it is possible to be constitutionally effective where your presentation of the alibi defense is hearsay testimony by a police officer who is testifying that the person he interviewed is a liar. I don't think that meets the constitutional standard for effective performance.
Now, that's not the whole of the alibi, right? You have two other witnesses.
You have two other witnesses who...
So this is the kind of the Ms. Fuller piece and how we're kind of plugging that into the defense, right?
This is the Ms. Fuller piece, which is the only witness who can testify, and Mr. Burkett admits at trial, is the only witness who can testify about where Melvin actually was at the time of the shooting, right? Because he says, the one alibi witness really isn't an alibi witness. She just says where he was after the fact. And the first alibi witness, which is Nashay, testifies that she left 30 minutes before. So those aren't actually alibi witnesses. And all they do is beg the question of where are Melvin and Melissa? Because the statements that trial counsel is eliciting from the prosecution also are not consistent with the other alibi witnesses he's putting on. What it seems is like he is bending over backwards to not call Melissa as a witness, even though he wants to call this alibi. And the reason that is a violation under Kyler is because he also represents Melissa. And because there is a signed stipulation between the prosecution and Mr. Burkett that is admitted before the trial, which says the outcome of this case depends on the disposition of this case depends on the outcome of People versus Melvin Willis. The prosecution have tried to walk that back and have tried to say, well, that's not evidence that the outcome of the trial mattered. It doesn't mean that he had to be convicted. But it's interesting the sister counsel points to Mr. Willis's statements at sentencing, because the actual full quote is, if I put people on the stand, one being my mother, that the deal that mother had with the prosecutors would be dropped if she testified at trial. And I would definitely get convicted, right? He is being told by his attorney that your mom has a deal. Your mom's deal will be dropped if she testifies at your trial. Whatever reason the prosecution wants to give for that, because Melvin will be acquitted and she won't get her deal, because they'll think that she's committing perjury and she won't get her deal, because if she testifies at all, she doesn't get a deal. Whatever the explanation is, her testifying at his trial, according to his attorney, is tied to her deal. That is an adverse interest. The conflict in this case is glaring. And it becomes even more glaring during the trial when Mr. Burkett starts objecting and saying that he needs a mistrial because there's a due process violation, because Melissa is not going to testify about the jail phone calls. And if the prosecution is not going to call Melissa, then we need a new trial because we don't know about these jail phone calls. My client is being denied a fair trial. And yet Mr. Burkett, who represents Melissa, does not call her as a witness during his defense case to question her about these jail phone calls, which is the obvious response to the issue with discovery. He doesn't even ask the judge, Melissa Fuller is not on my witness list, but could I add her now that this surprise exhibit has come in? He doesn't even try to call her as his own witness, but he's making objections that it's a denial of due process.
But I guess on this piece with the jail phone calls, I mean, is there, she has charges pending against her with respect to that conduct. So, what of the Fifth Amendment there?
So I think that goes to prejudice, right? Which is what Kyler says you don't analyze.
Why
Right.
does it go to necessarily just prejudice? I mean, I can see how, I can see how there could be an interest in not putting a witness on the stand just to claim the fifth when, that is obviously going to carry some implications for the jurors who hear it or.
Because when Mr. Burkett,
Any idea what that noise is? Okay. All right. Got it. Sorry. Go ahead.
because Mr. Burkett represents both Melvin and Melissa, which means he is not capable of advising either of them about whether or not Melissa should testify. Right? Exactly what the court is saying about the Fifth Amendment, right? So, and I think Judge Kunke identified this. People do not always follow their attorney's advice. So Melissa's attorney's job is not to convince Melissa that she must plead the fifth. Melissa's attorney's job is to advise her about the potential consequences of testifying at this trial, to make sure that she makes a knowing and voluntary decision, and then to help her execute whatever it is that she wants to accomplish, right? That's what an effective attorney does in this scenario. They don't say, you cannot testify, you must not testify. If Melissa says, under those circumstances, I don't want to plead the fifth, I do want to testify, then that is what her attorney has to help her do. Separately, Melvin's attorney's job is to evaluate what are the risks of calling her, what are the risks of calling her if she pleads the fifth, asking Melissa, would you testify? Would you plead the fifth? Potentially trying to convince Melissa and her attorney that Melissa should testify and that it doesn't carry risk for her, right? That's what he is supposed to be doing as Melvin's attorney. He is one person. He can't do both of those things. To the extent that he says in any way to Melissa, actually, I think it would be helpful if you took the stand and you didn't plead the fifth, he's acting in Melvin's interests. To the extent that he says to Melissa, you really shouldn't testify in this case, you're going to lose your deal if they put you on the stand, plead the fifth, he's acting against Melvin's interests. It's not a conflict that one attorney can contain and effectively represent a person at a murder trial. And I think we see the results of this, which is that if Mr. Burkett was telling the truth to the court and saying, my client is going to be denied a fair trial if this witness does not testify, why isn't he calling that witness?
And can you speak to the waiver piece a bit? Tell me, is it, because I don't think, I guess let me confirm, I don't think on the record that we currently have, we don't have particular information about the topic of waiver. Is that correct?
Right.
And is it your position that this is, well, I guess, why don't you tell me your position?
My position is this is an unwaivable conflict.
And
So-
tell me why.
So because to the extent that Melissa and Melvin would have had this conversation with Mr. Burkett, presumably separately, about whether or not they wanted to have these conflicts, the conflict under the rule for the waiver comes from Michigan Rule of Professional Conduct 1.7. And the test is, would an objectively reasonable attorney believe that they could simultaneously represent these two people without any material impairment of the representation of either person or any adverse effect to either one of them. And if an objectively reasonable attorney could look at that scenario and say, I see a material limitation or I see an adverse effect, the conflict is unwaivable. And the fact that the client says, I'm okay with this, is beside the point. I cite in my brief one of the ethics opinions, which is RI 176, which is a case where an attorney was in that scenario. He was representing two people who had come to him who said, we know we have conflicting interests, but we want you both to represent us. And we sort of decided amongst ourselves what we want the outcome to be. And the ethics panel says you have to withdraw from representation of both of them, because of what you know, because you want to be able to give them conflicting advice, and because your ability to give them conflicting advice is impaired by the interests of each party, you cannot represent both of them, and it doesn't matter that they want to consent to your representation. This was a retained attorney, that they had actually gone out and found him because he was familiar with their civil proceedings.
So from your perspective, it doesn't, no, no matter what we find out on the record about waiver, it doesn't matter because this just couldn't be waived properly. So it's just, is that right?
Right, which is why I believe Judge Kunke reached the correct decision. At the motion for new trial, she stated that the only reason that she could see for potentially holding a Ginther hearing that was not supported by the existing record was the question of waiver. And then she didn't explicitly say, but obviously she ruled she was not conducting a Ginther hearing, and she indicated that she believed it wasn't waived. That I don't think there is a way to waive this conflict, and especially because the way the rules of professional conduct work is that they are ongoing throughout the representation, right? Maybe you don't see the conflict at the beginning, but as the conflict arises, whether that's mid-trial when the jail phone calls show up, whether that's before trial when you're trying to figure out how to call this detective to testify and admit hearsay, at any point during the representation, once it becomes clear that these two people have adverse interests, when the prosecutor offers to dismiss Melissa's case, Mr. Burkett at that point can no longer ask them for consent.
No questions. Thank you.
Okay. Anything else, counsel?
Just, Your Honors, that I do believe this decision by Judge Kunke is supported by the existing record, by the statements that were made at trial, by the statements that are made extensively in the pretrial transcripts, which we provided in the appendix, and are supported by a just reasonable look at the evidence in this case.
Can I ask one procedural question before you wrap up? So just to tie the pieces together, you're in a position right now where a new trial has been awarded. The relief you're seeking in your direct appeal is that same relief, correct?
Yes.
You're looking for a new trial either on those bases or through affirmance of the one that's been awarded.
Right. And part of that is because we're in sort of unusual procedural posture.
No, I understand. Yeah.
So if this court, I suppose if this court were going to remand for a Ginther hearing, I would maybe ask that the brief on appeal be held in abeyance, pending the outcome of the cross appeal. But otherwise, yes, the request for relief is
all the relief is the same because some claims carry different levels of relief. But I just wanted to confirm sort of where all the claims are leading to the same request for relief, which is a new trial.
And part of the reason for that is because if the way that the time limits work, if we don't file the brief on appeal.
Oh, absolutely. Yeah.
Right.
Yeah.
Yes, but I don't think Michigan state precedent requires a Ginther hearing to be conducted. I think that's briefed in my response. But if this court does think a Ginther hearing is required, obviously, we also request that. But I do think this is supported by the record.
Thank you, counsel.
Thank you.
Thank you.
Any brief rebuttal? I think you're just about out of time. So if you have something quickly.
I want to point out that some of the arguments made by defense today about Ms. Fuller's Sixth Amendment rights don't apply in this case. This is just about Mr. Willis's Sixth Amendment rights, her rights to counsel. And we don't have any evidence that he specifically told her, you're not testifying. He gets to make those decisions. He can't say you can testify or not. It's his trial and he makes those strategic decisions. And he decided to not call her as a witness. And it's clear from the record why he would have done so. So again, I believe that the defense has not met their burden. However, if the court feels that there needs to be more record evidence about the defense attorney's decisions, about even why he called the officer, because it does sound like the defendant did want his mother called. The defense attorney decided not to call his mother or call the mother, but he still wanted that testimony out about the alibi witness. And so we don't know if that was perhaps the compromise reached between defense counsel and the defendant to call the officer. And so we just don't have that information. So if necessary, I believe a Ginther would clear up any questions the court has.
All right. Thank you, counsel. All right. Those
Thank you.
That case will be submitted. So I know we're just shy of our 11 a.m. session, but I think we're also well past it temporarily. So we're going to take our recess now, just about 5 minutes. All right, please be seated. I won't repeat all my admonitions to the large audience that we have here, but just a reminder, if your case does involve minors or vulnerable or protected persons, please do not use their individuals' names, but instead refer to them by their initials or something non-personally identified. Okay, with that, we will call item number 19, which is case number 367360, JB v. Farm Bureau General Insurance Company, and 367361, Mariah Incorporated, the Farm Bureau General Insurance Company.
Good afternoon, Your Honors. Matt Reddick on behalf of the defendant appellants. These matters have been consolidated for appeal. They were also consolidated for trial. There's two issues that have been appealed. One is the granting of no-fault attorney fees following the trial in this case, and the other is compelling defendant's expert to testify in plaintiff's case in chief. I want to speak about that one first. And our contention is that the trial court erred by allowing our retained expert, defendant's retained expert, to testify in plaintiff's case in chief. There's no legal authority for that. The cases we cited indicate that the adverse witness statute does not allow expert witnesses to testify. It only allows a opposing party to cross-examine a party, an employee of a party, and an agent, and a retained expert is not an agent. And also, the case law talks about MRE 611 that allows the court to control the conduct and how the trial is presented, but it does not allow the trial court to allow the opposing party to subpoena the expert. And that's why it's important in this case, because these were extraordinary circumstances that played out. I just want to go into that a little bit.
Quick question.
Yes.
This was a records only expert, right? This person never actually physically examined the injured person.
That's correct, Your Honor. And I think there's a distinction in that in the case law. So this was a expert that was retained to provide a report, and he did.
Counsel, we know all the facts.
Okay.
Here's the problem that I see.
Yes,
I
ma'am.
don't know about my colleagues, but it appears to me you're arguing something different on appeal than you argued in the lower court. I don't know if it was you or, but in the lower court, in your brief, there's a lot of court rules cited about expert witnesses, interrogatories, requests to produce, IME, court rule. I think an argument that the second amended scheduling order was violated. But there was no argument made that an expert witness cannot be compelled by subpoena to provide involuntary testimony, which I believe is your argument on appeal. So wasn't that waived? Wasn't this new argument waived?
I don't believe so, Your Honor. The motion was filed as an emergency motion on the eve of trial. And the reason for the motion was that the other side intended to call our retained expert at trial. And this was a emergency motion that was heard one day before trial. So there was not a lot of time to make that argument. And the adverse witness statute was not cited in the motion, but the motion sought the same relief. The motion was to strike the retained witness because he was retained as an expert, and Farm Bureau did not intend to call him as a witness. And so,
I mean, counsel, the waiver point though is, I mean, it's not just you objected to something because you didn't want it. You also need the specific grounds. And the life of the appellate counsel, you kind of living with what decisions were made below, for better, for worse. And I understand the exigent circumstances, but nonetheless, Where is this argument below?
I think the issue was preserved. I think on appeal, there can be additional arguments that support the argument that's made and additional authorities cited to support ultimately the argument in the issue, which was you can't call our retained expert. You can't force him to testify at trial. And so I think on appeal, you can present more elaborate arguments, even additional reasons for that. But I think the issue was preserved, and I don't believe it was waived, especially given the circumstances that this was right before, day before the trial, and it was in response to the surprise tactic that plaintiff was going to call this witness, informed the defendant that was going to call this witness a mere days before the trial. And so I believe the issue is preserved, and it certainly prejudiced the defendant in this case because the defendant had no intention of calling this witness. And how it played out is the jury learned that the witness provided a favorable report to the defendant, and that he, once on the stand, he reviewed additional records at the request of plaintiff's counsel, and that he testified he did not want to be there, and he testified he was not paid to be there, that he was paid to prepare the report on behalf of the defendant, but that based on these additional records, he completely changed and reversed his opinion. And so the jury, this played out live in front of the jury, and plaintiff notes that, and argues in its response to page 2029 that this was pivotal evidence on causation and on attorney fees. And I think there's no doubt that this was a turning point in the trial. And the jury even heard that plaintiff's counsel sent records to this expert, and that the expert declined to review them and contacted defendant's review company that hired him, and that the review company said, no, we don't want you to review these records. So it was even argued at the conclusion of trial that the defendant rigged this testimony, that rigged the opinion of the expert, and that they did not want his testimony to be played at trial. We do cite the Lozano court. I understand that is an unpublished case, but I think it's very similar and highly relevant and persuasive to this court, because in that court, the Court of Appeals ruled that it was error to allow the plaintiff to call, in its case in chief, the experts that were retained by the defendants. And
was that a PIP case?
It was not a PIP case.
Because I think the obvious problem here on this issue is that PIP cases have this unique element where the issue of whether it was reasonable for the insurance company to deny the benefit is an issue in the case. And so literally every piece of evidence that the insurance company has given that supports the claim is admissible because of that unique situation. So if they're given a report by their own expert that says something, that's a unique situation that doesn't apply in other types of tort cases, right? Because of that unique element that knowledge goes to the issue of reasonableness. And so do you have a published PIP case that holds similar to the argument that you're arguing here, which is that you could, even in the unique situation of a PIP case where reasonableness can be an issue, you can nonetheless withdraw an expert who has reviewed the file and given a report to the insurance company? You have something published in a PIP case that says that.
Yeah, I don't believe there's any PIP case that's published that says that, but I don't think this is dissimilar to other cases such as the Lozano, which was, I believe, a medical malpractice case. But in this case, the expert report was rendered after the decision to deny benefits was even made. It was rendered during litigation.
Except that in PIP cases, that issue continues up until the time of the jury verdict. Like, in other words, a no-fault carrier could decide on day 2 of a 10-day trial that they're going to pay a benefit, and then they don't owe attorney's fees for day 3, 4, 5, 6, or anything else after that. So that, again, that's a unique part of PIP cases, is that that issue continues until the day the jury reaches its verdict.
That is correct, Your Honor. But I would say that even in a PIP case, the defendant is allowed to control its trial strategy and is allowed to make decisions on what witnesses it will call and what retained experts it will call. And unlike Lozano, I think this is even more important, because in Lozano, the defendant acknowledged that it intended to call these witnesses, and the only issue was the fact that plaintiff was calling them out of order. Plaintiff was intending to call the defense expert in their case in chief. Here, defendant advised the court, advised counsel, it did not intend, it withdrew this witness, the retained witness. And so it's even more damaging, because this witness was not going to be presented to the jury, unlike in Lozano. And I think you mentioned the PIP cases. There is a difference, I believe, in and the cases support this, in a expert who is conducting merely a record review and an expert who is conducting an independent medical evaluation.
Yeah, because we can agree that, especially in any injury case, an expert who actually physically examines a patient, even if they're ultimately not called as an expert, maybe they're not, the other side's not allowed to call them as an expert, they're still a fact witness. The plaintiff's attorney in that situation could always call them and say, well, you did this test and it was positive for this, correct? In other words, the defendant in that situation might be able to prevent the plaintiff from asking expert witness questions of that expert, but they're a fact witness the second they examine that patient.
Absolutely.
Which is not what we have here. This is a records only review.
That's the distinction, I believe. And because there's no observation of the plaintiff, there's no evaluation conducted. It's the defendant's right to withdraw its retained witness and not have that witness testify at trial. And that's the cases we're talking about, I think, are Doring and I think it's Kisner that talk about that distinction. And I know, Judge O'Brien, you were on the Doring panel. And I think that distinction makes sense. Here, the jury would not have found out about this expert. And it's a matter of trial strategy. I mean, there was a reason that plaintiff shortly before trial, plaintiff started by filing a motion to strike this witness, and it was due to a late filing, an amended witness list, and defendant stipulated that we wouldn't call this witness, and then the expert was added to plaintiff's trial witness list, and so Farm Bureau said, "Well, wait a minute, something's going on here. This is our expert. This is our retained expert. Why are you now demanding that he? Why are you seeking to call him in as part of your case, Chief?" And so that's why the motion to strike him was filed on the eve of trial. And so I think the issue is preserved. I think it's an important issue, regardless of preservation. That I think the court can still review this issue, and I think it is a issue that certainly should be reviewed, because it's certainly prejudiced and changed the trial, and it was a tactic that plaintiff's counsel used, and this expert was on the stand for 3 hours, and he recanted his whole causation opinion that he had in a 16-page report, based on some additional records and some questions live in front of the jury. So on that issue, I think the court should vacate the judgments and remand the matter for a new trial. On the attorney fee issue, I think there was a question about a legitimate factual certainty at the time, and it's judged at the time that the decision to make the denial is made. And at the time of the denial, the testimony was, and the facts showed, that the claims adjuster, this was a 2025 accident, the claims adjuster paid all benefits, medical benefits, wage benefits through the end of 2025. And then learned that this gentleman returned to work. There were no further medical claims submitted. They closed the file in 2017. And then in 2018, they learned that all of a sudden this individual is residing at Eisenhower Center, a brain injury rehab facility, inpatient. And so what the claims adjuster saw was that the primary care doctor's records from that time in 2028 referenced that this individual was in a subsequent 2018 accident. And there was references to head injury in that accident. And the claims adjuster understood that these claims were also being submitted to the insurance company responsible for the 2018 accidents. And so based on that, the claims adjuster, who was still handling, it was the same adjuster, still handling the claim from 2015, made the denial decision. I think given the factual uncertainty of the two accidents, the fact that there's references to.
Look, can I ask you this, counsel? I mean, you can say that there's some factual uncertainty, but I mean, what's the duty to investigate here to see if there's actually an uncertainty? You know, in terms of, you can say, okay, yeah, I see there's two accidents here, you know, what's going on? But is that enough to then just say, well, no, I'm denying the claim? Like, how deep do you need to go before we can say, yeah, there's actually a legitimate factual uncertainty here?
Right. I mean, it has to be a reasonable investigation. And based on what I just mentioned, I think it was reasonable given the facts. I mean, she understood that, one, there was no.
Well, let me ask you this, because I think I understand the basic facts. So you disagree that it was reasonable. Is this an abuse of discretion we're looking at?
It is an abuse of discretion. The Zielinski case, I think, clarified that last one.
So it's not just, you know, the question is whether, we obviously know how the trial court felt.
Right.
So it's whether that is actually an abuse of discretion.
That is an abuse of discretion. Okay. Yes, sir.
Okay.
So unless the court has any questions, so.
No, thank you.
Okay, thank you, counsel.
Good afternoon, Mark Ronzaro on behalf of the plaintiff appellee. I am willing to concede that the first issue that the defendant raises involves an interesting and perhaps novel question of Michigan law. But as I think you already noted, Judge O'Brien, this issue that's interesting and perhaps novel has not been preserved for appellate review. I don't mean to bore you with the underlying facts, but I do need to stress a couple of things that happened. Obviously, the plaintiff objected to Dr. Shiner appearing at trial and made a motion. That motion was basically decided between the parties, as I understand it. They withdrew Dr. Shiner as a witness. What the plaintiff did then was to submit a trial witness list that included Dr. Shiner. The defendants then moved to strike that witness list. And it's very important, it seems to me, I don't think it was stressed enough what that motion was about, but I think Judge O'Brien, you've alluded to it, so you know what was in it. The motion said Dr. Shiner is not listed on any prior witness list filed by plaintiffs, and they never advised of any intent to call him. That was the objection. Defendant would be severely prejudiced to allow plaintiffs to call Dr. Shiner for the reasons detailed by plaintiffs in their prior motion seeking to strike Dr. Shiner. In other words, they latched on to the plaintiff's motion before. Okay, and then the brief is in support of that motion is in fact one paragraph long. It cites 5 court rules and 1 Michigan statute. What is not cited, and I took some notes while Mr. Riley was talking, what is not cited in that brief or the motion was Lozano, Daring, Kissel, the adverse witness statute, MRE 611. all of the substantive law that Mr. Wright has talked about today, that I wrote down as he was talking, none of that is in that motion. Then when they went to court to argue the motion, Mr. Wright himself was there, and his objection to this, allowing this to be added, Dr. Shiner to be added to the witness list was the following. But they're naming him as a witness on their trial witness list for the first time. That was the objection. That was the objection. And what you have to understand, well, first of all, I want you to know, I didn't write the plaintiff's brief. I'm a little late arriving in this case. But there was one part of the transcript that I had to read, and that was Dr. Shiner's testimony. And what I was looking for in Dr. Shiner's testimony is whether there was any objection to anything he had to say. And I can inform you with some amount of authority. The defendant made 4 objections during the course of Dr. Shiner's examination. 3 of those were based on leading questions. The 4th was a commentary that the plaintiff's attorney was testifying as opposed to asking questions. In other words, there was nothing, no objection at trial to anything that Dr. Shiner had to say. Now, if you get around to the substance of this, okay, the fact is, and Judge Wallace, I think, understands this perfectly well. The fact is that when Dr. Shiner is testifying with respect to what he did, he is a fact witness. He is not an expert witness. He's a fact witness on something that's highly relevant to any PIP case. Okay, and that is how they treated the claim. There was no objection. Obviously, the claims rep in this case was on the stand for a significant amount of time. There's no question that that's relevant. For the same reason, when Dr. Shiner is testifying as a fact witness, there really is no objection legally to what he has to say. What's interesting and perhaps novel, I will grant you, is when he started giving opinions. That gets into a totally different area, but there was no objection at trial for that. MRE 103 is crystal clear. MRE 103 says, in order to challenge on appeal any ruling regarding the admission of evidence, you have to have both a timely objection and it has to be on the same grounds that you raise on the appeal. That's what MRE 103 says. And I think it's important to look at MRE 103B in this context as well, because that's the rule that basically says if a judge decides a motion is limine, you don't have to re-raise your objection at trial, the way 103B is written. Okay, but what it does say is if there is a definitive ruling, okay, made by the trial court, even before trial, you don't have to make another objection. All that the judge decided in this case is that Dr. Shiner could testify. That's all. He didn't say anything about what he would testify to. That was left for trial, and there was no objection to anything he said at trial. So again, there's an interesting question. Could Dr. Shiner give his opinions? That to me is a little bit different because I think when he's talking about facts, this case is quite analogous to the Kissel and Daring case. Kissel and Daring stand for the proposition. I think it's pretty simple. If you're an IME doctor and you examine the plaintiff, you can become a fact witness. Okay, and to me, part of what Dr. Shiner did in this case was as a fact witness, and there's nothing wrong with calling him in that respect.
Does the records only distinction matter?
Pardon?
Does the records only distinction matter?
Yeah, the records only. Yeah, he never saw JB. He never examined him.
But that doesn't affect, from in your perspective, his ability to testify as a fact witness.
It does not affect because he gave his opinion based on what he was supplied. That was obviously one of the critical pieces of the information that he provided as a fact witness. Here's the information I was given. Here's the information I wasn't given. That's a fact witness. I don't think there's any problem with that. But when you get into the realm, I acknowledge this, when you get into the realm of his opinions, this is a little more problematical. This is the novel issue of Michigan law, it seems to me, but it's not preserved. They had to object at trial because there was nothing about it pre-trial about what he was going to testify to.
But we can, we can overlook that if we so choose, right? I mean, MRA 103
You
says
can't-
we can take notice of plain error affecting substantial rights. We can,
That's funny because I read 103A differently. 103A says, well, I copied it for their purposes here. 103A says if you're going to challenge something on a party may claim error in a ruling to admit or exclude evidence only if the error affects a substantial right and goes on to say the ruling a timely objection to move or strike or the specific ground. So the fact is he had in my estimation a legitimate chance to object to a certain part of testimony made at trial, not before trial, at trial, and there was no objection.
but the last subsection of the rule says a court may take notice of a plain error affecting substantial right, even if the claim was not properly preserved. Right?
Okay, you're right. You're right. I read to 103A incorrectly. Okay, but the point is, it's not his testimony was not completely wrong. There would be again, I will admit, somewhat interesting and novel issue of Michigan law with respect to him giving opinions. Okay, but if the objection had been made, he would not have presumably done so. Now, moving on to the attorney fees issue. I think you know, Judge Mariani, there is a lot of factual uncertainty in this decision-making process. When the claim was denied, there's no question that Ms. Her name is Damzalski, that Ms. Damzalski did not have much information regarding the claim that was being made, but the Supreme Court, and obviously in 3148 as well, speaks to legitimate factual uncertainty. And it's just sort of that word that has been written out by the defendant in this case. It has to be a legitimate factual uncertainty. And what Ms. Domzalski said in the original letter denying it is, hey, I know he's been involved in another accident, 2018 accident, as opposed to the 2015 accident that Farm Bureau covered. That's correct. He was involved, but if she actually looked into it beyond what she got, she would have seen that his injuries consisted of lacerations to the face, nothing compared to the severity of the injuries associated with the 2015 accident that took place. She got these bills. They were triggered by the Eisenhower Center. She got these bills from the Eisenhower Center, obviously for a traumatic brain injury, and she makes no effort to talk to the people at the Eisenhower Center, sends no letters to them, doesn't contact any of the doctors. There's a ton of factual uncertainty, but the fact is, it's an uncertainty that was in essence created by Ms. Domzalski's own lack of investigation. And, this is a trial judge who sat through the trial, saw her testify, and saw her get cross-examined when she gave answers. So, for example, she writes in her denial letter about the 2018 accident, but when she testified at trial, she has to concede, no, I really didn't look into the severity of the accident. So we have a judge who sat through the trial. We have a deferential standard of review, and we have more of the Supreme Court saying that the reasonableness of a particular decision applied to particular facts is a factual question, obviously subject to deference, and the trial judge who sat through the trial made those findings. Any questions?
Take further? Okay, thanks, counsel.
Thank you.
Just briefly, Your Honors. I think there is a distinction here between a fact witness and an expert witness. And Dr. Shine was not a fact witness. He had no facts that he could testify to other than his expert review of the medical records.
I think the fact would be that he formed certain opinions, maybe created a report and gave them to the PIP carrier.
That's right.
So in other words, if your client had objected to his testimony on any expert opinions, presumably that would have been sustained because due to the fact that your client had withdrawn him as an expert, he would not be able to give expert opinion testimony that substantively addressed the issues before the court at that moment. However, none of that changes the fact that his opinion itself, as long as there was evidence that it was given to the PIP carrier, would be evidence of reasonableness or unreasonableness of denying the claim.
Right. I think, I mean, the trial court explained it in the on the hearing on the motion to strike that, well, you know, defendant can take a discovery deposition of this expert if it wants to. Well, this was our expert. I mean, there's no reason we believe to take, Farm Bureau believed to take a, you know, discovery deposition of your own expert.
Yeah.
This would be different, I think, or less egregious if he rendered the same opinions in his report. But here we have a retained expert who completely changed his opinion on the stand. And that
what do you think about Mr. Granzato's argument that that essentially what happened as far as the pretrial motion was concerned is the ruling was that the doctor would be allowed to testify, but then when he started offering expert opinions, counsel for your client didn't object. So is that not a waiver?
Well, I don't think it is, Your Honor, because the motion to strike was intended to strike him as a witness completely. So, you know, whether objections are made during trial, whether post trial motion is filed, I think the motion to strike is enough to preserve that objection and that issue. And as the court noted, I mean, even if the issue wasn't properly preserved, which I believe it was raised and decided, you know, the court can review this for plain error. And I think this is a case where it was error that affected substantial rights of the party. I mean, the party the expert has a property right in his own opinions and cannot be made by subpoena to divulge those at trial. And that's what Gandhi, I believe, states. And the other thing is, you know, it's a matter of trial strategy as far as who you call as a retained expert. And this essentially turned this expert into a retained consulting expert because he wasn't going to be a testimonial expert. That decision was made in advance of trial. It was only when plaintiffs said, we're going to name him as an expert and we're going to use him in our case in chief that you know, the motion to strike was made and the objection was made. And I think, like I said, because of the testimony that was rendered, because of the arguments that were rendered in front of the jury, I think this substantially prejudiced the defendant and enough to mandate a new trial.
Okay,
Thank you.
All right, that matter will be submitted. All right, moving on to item number 20, 374065, Van Heetsma, be the estate of Myers.
Good afternoon, Your Honors. May it please the court, Mindy Schwartz on behalf of the estate of Claude Myers.
Great, just 1 second.
I'm sorry.
Hi, Judge Mariani, this is Stephanie in the court the clerk's office here, and she did not show up in the gallery. The appellee attorney did not.
Okay, well, her appearance is limited to answering questions from us in any event. So I think we can proceed.
Thank you, Your Honor. To be honest, we primarily rest on our brief.
Okay.
The other side didn't even see fit to respond at all to this matter, so I don't know what I would argue with them. This is, if you have any questions, I'm certainly happy to answer them.
Questions? No. Okay, I think we're all set. Thank you. Okay, that matter will be submitted. Moving on to item number 21, case number 372052, Hullins v. MGM Grand, Detroit. And I believe we have plaintiff appellant. I don't see as. Oh, I see. That was dramatic. We have counsel for plaintiff appellant in person, and I believe we have a remote request granted for counsel for defendant appellant.
Good afternoon, Your Honors. May it please the Honorable Court, Dewey Rick Martin, here on behalf of the appellant in this matter, Mrs. Johnny May Collins. Your Honors, one of the most popular sayings in our country is that no one is above the law. No corporation, no person, no individual. The problem is that that rule is not always applied. And that happened in this case. The question before the court is a narrow question. Did the trial court err as a matter of law in granting defendant's motion for summary disposition, despite the fact that it was improperly supported by documentary evidence that did not fall under any exception to the rule prohibiting hearsay of out-of-court declarants? Your Honor, the reason why I say it's a narrow question because the case which we cite in the brief, Bernard Manufacturing Incorporated versus Gates Performance Engineering, 285 Mishap 262, 2009. In that case, the court made clear that before the trial court can consider or even analyze a motion for summary disposition under C10, the motion must be supported by substantively admissible evidence. The court goes on to say that if the moving party fails to meet that initial burden, the non-moving party has no duty to respond, and the trial court is required by law to deny summary disposition.
So, counsel, what I want to better understand, I guess, the scope of your position here. Because it sounds like you're saying if a party submits a motion for summary disposition and there's a piece of evidence in there that shouldn't be considered, then the motion is categorically not properly supported, regardless of what the other evidence or arguments are. Is that what you're saying? There's just like one piece of evidence forecloses further consideration of the motion? Because I have not seen that authority or application in terms of how we consider summary disposition.
Well, C10 says a motion for summary disposition can only consider admissible evidence.
Right. So you get the motion, you figure out what's admissible, and then you consider it.
If the motion is improperly supported by inadmissible evidence, the case law is clear. It says the motion
counsel,
is.
I understand, but this is what I'm trying to ask you. So if I agree with you that the evidence, the pieces of evidence that you have identified are inadmissible, right? Our review of summary disposition is de novo. Okay, so we say, okay, we agree. Those pieces of evidence should not be considered. What we have, though, is still the rest of the motion and the arguments that have been made and the rest of the evidence that have been presented. And that, what remains, can still demonstrate entitlement to summary disposition.
Okay.
So I guess I'm not totally sure if just kind of saying these pieces of evidence were properly considered carries the day necessarily. Do you
I understand,
okay.
Your Honor.
Are you arguing otherwise?
Yes, that's
Okay.
the initial argument, saying that the motion was invalid as a matter of
Because
law.
it included. some
It
pieces of
included,
okay.
right.
Thank you for
Now-
clarifying. Okay.
Now, the next question is, and it gets to what you raised, Your Honor. How were those documents used? Those inadmissible documents. There were two pieces of evidence that goes to the heart of Ms. Cullen's claim. Two pieces of evidence that were attached, that were inadmissible, that goes to the heart of both of her claims. The one piece of evidence was Dr. Ager's report. Dr. Agers stated in his report that the trial judge relied upon that Ms. Cullens was accommodating. Her request for accommodation, which was either 4 hours sitting, 4 hours standing due to one knee replacement and another knee problem that was submitted by her physician and surgeon, or for sitting, a chair. That's the only way you could sit at the casino is in a chair. Well, Dr. Ager stated in his report, when she last worked, she was working 4 hours sitting, 4 hours standing. And that when she last worked, they had her wearing a gray suit. That was the ID checker job. The question is, did the judge rely upon this inadmissible evidence? And let me state, first of all, why that evidence is inadmissible. Number one, under the hearsay rule for medical documents, it's controlled by Murrow, the Supreme Court's decision in Murrow, which we cited. Murrow makes clear that unless the person is being treated or seeing that doctor for treatment or diagnosis for treatment, it's inadmissible. Under the MRE 803-4, it specifically talks about medical diagnosis and treatment. She was not seeing Dr. Ager for that. In fact, Dr. Ager admits that she was not being seen for medical treatment. He stated at the beginning of his report to the attorney representing MGM in a workers' compensation litigation. He states, in response to your request, I attempted to perform a psychiatric evaluation. And he goes on and states, she understood that was a one-time evaluation. There would be no doctor-patient relationship, and that it was not my purpose to provide her with any treatment. So right there by this letter itself.
So what evidence do you have that the trial court relied upon that report to come to the conclusion that she had been accommodated?
We cited in the motion for summary disposition transcript, Your Honor.
The hearing transcript?
The hearing transcript. And let me pull that up. Page 64, Your Honors. The trial judge stated, and when she went to the ID checker job, I'm sorry. You're wrong. I had that right here. What I could do, Your Honor, it's in the transcript.
We have
In rebuttal.
We have the record. We have the complete briefs. So we have
Okay.
it submitted and we can, if you don't have it on hand, that's okay.
Okay, but I would like to state it in rebuttal. But the trial judge specifically stated that she was accommodated with 4 hours sitting and 4 hours standing. And she specifically stated that that came from Dr. Ager's report. That's the only place it came from. Because in her deposition testimony, she vehemently denied. In fact, there's a litany of her testimony where she denied the accommodation. So based on that finding by Dr. Ager, which was inadmissible, the trial judge relied upon that to find that she failed to state a claim of accommodation to support the accommodation claim. In other words, the trial just said that she was accommodated. Well, that's not true. And
The trial judge
I'm sorry.
also, the way that I read what the trial judge said was that she was dismissing the persons with disability claim because the plaintiff's disability was directly related to her ability to perform an essential function required of an individual working as either a security guard or an ID checker for defendant. And that the plaintiff failed to proffer any evidence that would create a genuine issue of fact on that issue. And secondly, to the extent the plaintiff's failure to accommodate claim was premised on defendant's failure to provide plaintiff with a chair, that claim had to be dismissed because plaintiff failed to provide any evidence tending to establish that she ever asked or made a written request for the chair. So whether the judge ever referred to this report from the doctor, she gave two other bases for dismissing the case.
First, Your Honor, the chair is something that comes up if the doctor says, her doctor, her surgeon, said she should be sitting 10 to 15 minutes every hour. That's where the chair comes up.
Right, and the judge said there was never any proof from the plaintiff that she made a written request for a chair.
There's a written request from her doctor and surgeon that she be allowed to sit. Sitting means using something to sit on. I don't think if we are going to do a motion for summary disposition, all inferences are to be drawn in favor of the plaintiff.
But isn't there a difference between a restrictions prescription and a formal written request submitted by an employee for an accommodation?
It was submitted by her doctor. In fact, MGM sent a form out saying, what is your accommodation needed? It's right there in the exhibit. It's several pages long. And in there, Dr. Williams specifically said that due to her knee injuries, which were work-related, that she needs to sit, or otherwise it will aggravate both knees. He found both knees were a problem. One she had totally replaced.
But did she submit a written request with that restriction to
MGM.
the defendant asking for a chair?
She sent the request asking that she'll be allowed to sit down. And her claim is not just a chair, Your Honors. It is to be able to sit. It is to be able to sit. That's exactly what her doctor said. You need to sit 4 hours of the workday. You need to sit.
And then the court also found that she wouldn't be able to do either of the jobs because she had to sit, that she was not, the failure to accommodate claim has to fail because she couldn't do either job. You can't sit and be the ID checker or the security.
Well, okay, so if we're going to get into the facts, which is good because that's a factual dispute. We have an affidavit from my client and also from another security officer, Branch, who said, Mark Costello, who weighed 400 pounds, he also failed the test. He was demoted to the same job that my client was demoted to, ID checker. Defendant belatedly in argument said that you can't use a chair at that post. Branch said that Mark Costello was given a chair. Now, Mark Costello did not have any work-related injuries. Mark Costello had an obesity problem. He weighed 400 pounds. This is why he could not pass the 4-minute test, along with another individual who did not pass the 4-minute test. Cole, security officer Cole. Why do we know he could not have passed? Because he was paralyzed, unfortunately, from a stroke. He was paralyzed on his entire right side of his body. Now, he was required, along with my client, to pick up a 50-pound medical bag, run 100 yards, up 8 flights of steps, and then when you get there, do chest compressions, CPR. Well, a reasonable jury would say that's impossible. Impossible for a person paralyzed on the right, dragging their leg to do this in 4 minutes. So that, again, these are factual questions. She was denied a chair, but Mark Costello was given a chair. Mark Costello did not have work-related injuries. Ms. Cullins had work-related injuries. There was a specific request for her to sit. And I think a reasonable jury could say, wait a minute, well, sitting, you need a chair. I'm sure the doctor did not mean sit on the floor. And yes, she was able to do the essential functions of her job. What is an ID checker? They stand there or they could sit. And at one time, Your Honor, they did have chairs. She used to sit in a chair. MGM decided one day, well, we're going to get rid of the chairs. Now, brother counsels are going to say, well, for security reasons, but that was not the reason she was given. She was never given any reason. This is all after the fact. So even if they got rid of the chairs, but you have testimony under oath that they gave a chair to a similarly situated worker in the ID checker position who weighed 400 pounds and failed the test. He was allowed to sit. So workers coming in every day seeing this man sitting and Johnny May Cullins not being allowed to sit.
So when these affidavits that you're talking about, they refer to sit-down posts. Were the only sit-down posts the ID checker jobs, or were there other sit-down posts?
But there were several other sit-down posts. In fact, the gentleman who unfortunately had the stroke and was paralyzed, he was never even demoted to an ID checker position. Now, the stroke was personal. So he didn't have a work-related injury, but yet they accommodated him. They never assigned him to an ID checker. That's a difference in treatment. It's up to the jury to say, was this difference in treatment due to Ms. Cullen's filing and exercising her rights under the Workers' Disability Act to treatment? Because she did, for her knee. And when she failed going up the steps, she cut herself. Her doctor told her not to do it again. She tried it again because she wanted to keep her job. And she was injured going up the steps. There's absolutely no reasonable explanation that the defendant has presented to the trial court or to this court to justify not allowing her to sit or even relieving her. They didn't do that. They were supposed to relieve her every 10 or 15, every hour for 15 minutes. That's a reasonable accommodation. They never said it wasn't. In fact, they never responded under the act. And like I said, this is the law. You have to justify when you do not accommodate a disability. Furthermore, there's not one affidavit from MGM in this case to say any of the things, Your Honor, that you just asked me. Not one affidavit. Not one. The plaintiff is the only one that presented evidence in this case. This is why the trial judge was wrong to say plaintiff did not present evidence. It was a defendant who did not present evidence. How often you get a case, a motion for summary disposition, and there's no affidavit from the moving party? Not one. And that's what happened in this case. So number one, if you relied upon Dr. Ager's report, which the court did, well, that's a factual question. Because you'd see pages in her transcript, she testified that she repeatedly asked, not just for a chair, Judge O'Brien, but for a break that her doctor said she needed. No, she could perform the essential functions of that job.
Hey, counsel,
she was doing it.
I think part of a broader problem that we may have here is your brief does not get into a lot of this as I read it. It says this evidence is inadmissible and therefore the motion should have been denied.
Your Honor.
And I see that for both pieces of evidence. You make arguments about their admissibility and then you say, because these constituted inadmissible hearsay, therefore the trial court granting summary disposition must be vacated and reversed.
Your Honor, even though our position initially was that we had no duty to respond because the motion was improperly supported, we did respond. The trial judge says there's no evidence, and the trial judge improperly ignored page 13 of the brief that's on appeal, which was in the trial court. Unlike the defendant has added all arguments after the case was appealed. There's no argument in the motion for summary judgment for the defendant on admissibility of any documents, none in the trial court. How can you do that? What are you relying upon? You didn't make one argument for admissibility, not one.
But I understand, counsel, but I guess my point is that we're getting into a lot of arguments and defenses of your position that have not been presented in your brief.
Okay. Ms. Collins testified in her deposition that
this is the factual summary, and then you have your arguments, right? And
it's in the brief, Your Honor.
You have to make arguments, though. It's the arguments that you present begin on page. Argument section begins on page 16, right? And then we have arguments about admissibility and how the fact that these documents were inadmissible rendered the motion improperly supported. And I understand sort of what your procedural position is on that. But what I'm not seeing is actual arguments being made about why, if you look at everything else as it was, it is actually sufficient to defeat summary disposition. And I know that's, we'll hear from opposing counsel about that, but I think that's just a presentation issue that we have to grapple with. in this.
Your Honor, and I understand, I appreciate that. But under the court rules, and this is de novo, so you look at the entire record. Well, if you look at the entire record, she testified, and it's in the brief. It's attached to the brief, her transcript. I mean, her deposition testimony. So is the court going to ignore that? She says, I requested to be accommodated with sitting or a relief numerous times, and it was denied. Brian Humphreys, I took Brian Humphreys' deposition, who represents the defendant. The defendant didn't. The defendant submitted nothing but Dr. Ager and test results. The test results are inadmissible. First of all, they're not inherently trustworthy because of the things I just mentioned about the two individuals, but also the person who authored that document, Candace Hicks, she's not even on the witness list. So the defendant is going to argue, well, we could clean it up at trial. No, you can't. The person is not on the witness list. Candace Hicks was never listed. But throughout, in the statement of facts, and all of this is what the trial judge considered, Your Honor. These arguments that you're asking for were made to the trial judge. On appeal, we went with the strongest argument in my mind, but also we attach the record because this court does de novo review. So the question before the court is,
well, we do de novo review, but it's also shaped by the presentation of the issue to us.
Okay. I understand,
de novo review of the record based on the arguments that have been presented.
We're limited to the question presented as well.
Now, I also want to advise you that it sounds like you're interested in rebuttal.
Yes.
And you have about 4 minutes left in your 30.
Thank you.
So if you want to save that.
Yes, thank you.
Okay.
You.
Okay. Counsel.
Mr. Presiding Judge, and may it please the court, Joe Rashad appearing for MGM Grand Detroit. Your Honors, I appreciate the opportunity to appear remotely this morning. I intend to be brief. I really want to address the question of Dr. Ager's report. We've heard a lot this morning about hearsay, but I would submit to the court that Dr. Ager's statement is in fact non-hearsay because it would be the statement of a party opponent and therefore be admissible under 801 D2A. The real issue.
It seems like there's fact questions about, I mean, regardless of the hearsay issue, I look at the record, it seems like there's fact questions about, whether, accommodations, were made or should have been made. But I guess what to counsel's point that there's fact questions that pervade, all the issues here.
Well, I would disagree with Your Honor respectfully. We don't think that there are fact issues. At the end of the day, we have job descriptions that require certain performance metrics. This case arises, of course, in the shadow of the Mandalay Bay massacre where 60 people were killed. As a result of that, MGM and Ms. Cullen's union established certain physical agility requirements that employees have to meet. Ms. Cullen's own medical records show that she's unable to meet those requirements. We heard this morning from Brother Counsel, one of those requirements is that Ms. Cullen's and all CSOs, casino security officers, be able to pick up, I think I heard a 50-pound bag, my notes reflect a 30-pound bag. Regardless, her medical records show a 10-pound weight limit for her to be able to lift. She's not able to kneel, according to her own doctors and the medical records that she put into evidence, and that we also, I believe, put into evidence. The court can take judicial notice that CPR is generally administered when somebody is prone on the floor. The person administering the resuscitation has to be over the person on their knees to perform the chest compressions and any of the support breaths that are necessary to be administered. She's not able to run. She's not able to climb stairs. as we've demonstrated throughout the record here. So her own medical records demonstrate that she's unable to perform the essential functions of the job. On top of that, and it sounds like from brother counsel against medical advice, she tried to do that twice. She failed both times. And it isn't as if MGM is looking to be unfair here. As we pointed out, the contract between the union and MGM required only 2 attempts, and she was offered a 3rd attempt, which she declined. So with respect to whether there are fact questions, I would say, again, her own medical records, the testimony that we introduced from her deposition demonstrates that there is no fact dispute when it comes to the CSO job. Again, I would also submit the same is true for the ID checker position. With respect to the ID checker, the requirement is that you be able to stand for 5 hours at a time. One physician in the record says 1 hour limit in an 8-hour day. The other physician says a 2-hour limit, provided that you're able to take breaks in, I think, 15-minute intervals, if I was able to read the kind of poorly photocopied document that was submitted. So we have somebody who, for safety reasons, is unable to sit, at least in the specific ID checker job. This is distinct from what Judge Wallace mentioned, that there are other jobs that can have employees in the seated position, but not in the position of performing an ID check. The undisputed material fact in the record is that that is a security safety requirement, because the person who is sitting can have somebody come up behind them, can either attack them or in some way interfere with the operations of casino security.
And counsel, what about the point that another employee, Mr. Costello, was given a chair? Can you respond to that?
Well, Your Honor, I don't believe that Mr. Costello was given a chair in this particular position. My memory is that he was allowed to be seated in one of those other positions, which of course then would not make him similarly situated. So I don't know that that's an issue that we have, but of course we're also dealing with the McDonnell-Douglas test. And so while our position is that there is no evidence that would meet the prima facie requirement for Ms. Cullens, even though she's the non-moving party, she seems to forget that she has that initial burden of establishing a prima facie case.
Well, it's your motion, though, counsel. So, I understand what you're saying analytically, it's substantively, but also it's your motion. So you've got to start us off there.
Yes, understand. So we do, in terms of laying out why there's no prima facie case. We have these essential requirements. She can't meet the requirements. And so therefore there's no prima facie indication of discriminatory treatment or failure to accommodate when you can't do the essential requirements of the job. So even if we spot her that argument, which is what we do then analytically in the brief, you move to the legitimate non-discriminatory reason. And it's undisputed, and I don't hear anything from brother counsel today, much less in briefing, addressing the fact that his client was unable to return to work after 2 years. And the case law is pretty clear, as we've laid out in our brief, that when you have that kind of a temporal gap between the allegedly protected activity and the adverse employment action, you don't have really a prima facie case at all. But what you do have in any event is a legitimate non-discriminatory reason, in which case the burden would shift back to Ms. Cullens to establish that there was some pretext behind the decision to terminate her. And I haven't even heard that today, much less in the briefing and the record below. So in our view, we've laid out how at each prong of the McDonnell-Douglas test, Ms. Cullens has simply failed. Even though it's our motion, we have the ultimate burden of persuading the court that C10 is appropriate. There are certain shifting burdens throughout that test. She just hasn't met them, whereas we have on the undisputed material facts. And so given that, Your Honor, and given the points that have been raised in argument this morning, for example, Judge O'Brien noted that there were other reasons that the trial court gave beyond Dr. Ager's testimony. the point that you made earlier, Judge Mariani, that just because a single piece of evidence might not be admissible, and again, not conceding that issue, but that doesn't change the calculus that all of the rest of the evidence can be taken into account, which is what we urge the court to do here as part of its de novo review. So we've laid out all of the tests, we've laid out all of the evidence, and the reply brief, and indeed today's argument, other counsel hasn't addressed those issues. So it's a little difficult for us to respond today to perceived deficiencies in our motion papers and our brief on appeal. We don't really have any argument from brother counsel articulating why our positions are incorrect. So for those reasons, Your Honor, and of course, if the court has any questions, I'd be happy to answer them. We would ask that the court affirm the circuit court in all respects.
I have a question. What were those other sit-down positions? We already know there was the ID checker that was not a sit-down position from what you're telling us here. What were the sit-down positions?
I believe one of the positions was at like a employee check-in station in the back of house. I could be mistaken about that, but I believe that that is where the seated position was. In terms of other positions that security may have had at various points around the casino, I'd have to go back and comb the record to give Your Honor a more detailed description of each one.
That's okay. I just want to know what you remember as you're here today.
Yes, yes. So my memory is, again, that is a back of house position and part of a rotating position as well.
Anything further? Okay. Thank you,
Thank
counsel.
you, Your Honors.
Thank you.
One thing I noticed that brother counsel did not do, he did not address the factual dispute regarding Costello being allowed to sit after failing the physical agility test.
My understanding, counsel, because I was curious about that myself. My understanding is opposing counsel's position is that he was involved in a different position.
No, an ID checker.
ID checker
No,
position.
it was ID checker. The affidavit of my client and Mr. Branch, it was ID checker. That was the only job you were demoted to at that time under the union agreement. And our main argument is not about the security position. She failed that. We're not arguing that. The issue is the ID checker, which with accommodations, the same accommodation given to Mark Costello, which is being able to sit or given breaks, she would qualify. She would qualify for the ID checker. In fact, she was doing that job. She was doing that job the day that she left, and the next day she was admitted into a hospital for a breakdown. And she testifies that what led up to that breakdown. She was in pain every day doing the ID checker job, and there was absolutely no reason why they did not give her relief. In fact, I asked Brian Humphreys, her supervisor, and he admitted. It's in the deposition. He admitted, well, if I could, I do it sometimes, or I didn't have people or whatever. But again, as you stated, Judge Mariani, it's the defendant's burden to show that there's no disputed facts in this case. They have not met that burden. She met the initial elements for failure to accommodate. We have a letter from her doctor. She was, in fact, they have a letter here. MGM submitted a letter on November 13, 2019, exhibit number 6 to Ms. Collins. This is after she failed the test and she was going to be moved to the ID checker job. The company has received your request for accommodation under the American with Disability Act to perform the essential functions of your position as a security officer. You have requested sitting accommodation, limited kneeling, to be excused from agility tests, and scheduling accommodations. After reviewing the information you and your physician have provided, we are pleased to inform you that we have granted you a request, a reasonable accommodation. And then it states, pursuant to your physician certification, we are provide you with lifting and kneeling accommodation. They did not say sitting accommodation and provided no reason for failing to honor her request for accommodation to sit. And then that letter goes on and says, after that time, you will be expected to take the agility tests again. You declined and chose to continue as a ID checker. So she met the qualifications of ID checker. Here's the letter. You chose to go as an ID checker effective Monday, November 11, 2019. On November 8th, you were told that a scheduled accommodation request would require supporting information from your provider.
Counsel, I'm sorry to interrupt you. But
Okay.
Your time is up.
Okay, Your Honor, I just would like to end by saying that the focus is not determination in this case. It is being constructively discharged when they failed to accommodate her as an ID checker, which led to her being hospitalized. Your Honor, I believe that this case is literally pregnant with factual questions, and the motion was improperly granted, and I request that it be vacated. Thank you.
Thank you, counsel.
Okay, thank you both.
Oh, excuse me. It's page 58, Judge O'Brien, where the judge says that, in fact, for a period, she was permitted to sit for 4 hours and then stand for 4 hours on page 58 of the transcript. So
Thank
the
you.
judge did rely upon that, and that is a factual dispute.
Thank you, counsel.
Thank you, Your Honor.
Okay, that matter will be submitted. Item 22, case number 378-518, Inri King Minors.
Hey, please, court, Brandon
No, just pause 1 second. Mr. Martin, are you all right if we proceed to the next case with counsel? Okay. Sure, absolutely.
No problem. Thank you.
Is that all right with you?
Absolutely.
Okay.
May it please the court, Brandon Mackman on behalf of the appellant, the respondent mother in this case. There's two numbers I have for you. There's 4 and 9. 4 months is the number of months that she had where she actually had parenting time, and 9 months is the amount of time where DHS worked to reunify her with the children. And that's it. I think that's relevant as I reread my brief, and I appreciate, and I apologize for having such a long brief. It's 40 pages. But my client did a lot of positive things in the case. She completed the services, she did the parenting time, drug test, etc. My client's president, I explained to her before what clear error meant and what the clear and convincing evidence standard means, and I think they're both relevant here. But they play both ways. You have to have clear and convincing evidence to terminate, but you also got to apply the right evidentiary standards and follow the rules. So I was always taught you should probably tell the court why you're going to win in the very first couple sentences, and what you put at the beginning matters. Well, in the court's beginning of the court's oral opinion, they reference the second, reason parenting time was suspended at the beginning, the sexual assault abuse allegations that were ultimately determined to be unsubstantiated. And she wasn't put on the registry. And the Michigan State Police investigated it, found it wasn't credible. CPS found it not credible. No charges were filed. And that's important because that's a supplemental allegation. It had no basis, no belonging in the opinion, and that's where it starts. And that's argument 2 of my brief. I understand that evidentiary issues are abuse of discretion, but I'm sure the court's aware. We have a lot of these appeals, and they read like stories, and you start at the beginning, and you're always, as you're reading through them, you're looking for that watershed moment. when did the tide turn? As you read it, you're like, even as an appellant, when we're representing the parents, we cite, we got to massage that one part in the statement of facts. We're like, yep, this is where everything changed. This is where they filed the petition, and this is where it all went hayward for the parent. Well, as you read this case and you follow this case, it's this second time parenting suspended because of this allegation. After that, that's the watershed moment. That's when they stop working with her. That's when the termination petition gets filed. And and again, abusive discretion, it's the source, right? At the termination trial, how's it come out? Who's the source of this unsubstantiated allegation, which doesn't get put on the registry? It's the relative placement, who the CPS worker admitted from the very beginning. This is a contentious relationship with my client and the relative placements. It's a contentious relationship. Well, this contentious relationship is also the source of the inadmissible hearsay. Okay. And this source is the one who wants to 199% adopt the child. Okay. I mean, there are things we can do if we wanted to present this evidence that was legally admissible. We have the tender years rule exception. We have the context. I mean, we have all these rules that we could have applied to make this admissible evidence if we wanted to. No one did it. So I think that's an evidentiary issue. I understand the tough standard that I'm up against in abusive discretion, but the placement in the opinion matters to me. And that's what she led with, the judge. And if she leads with that, and then I look at the rest of it, and I know it's the last case of the day for you, and I know you've read the briefs, but the positive things that she did, again, they don't like her housing. Okay. Yeah, living in a tent in extreme poverty is not the best start to a case. But in 9 months, when you're living in a domestic violence shelter that accommodates children, I say that's progress. I say that's great progress. And then and I briefed this extensively too. That was their other big complaint. I get it. Like, yeah, she was wrong on admissible hearsay, but we still don't explain the housing. She still didn't have housing. She didn't have independent, suitable housing. Well, I got an argument against that too. And I'll push back on that, because when you're being chased around by a perpetrator, when there's PPOs out, when the other guy has domestic violence thirds, and there's no contact orders, I don't know that you want to be outside of a shelter. I don't know that a shelter is not the best place to be. And I briefed that too as my pushback on saying, well, she still didn't have housing, so the judge didn't clearly err. I don't think that housing's unsuitable. She was ordered to stay in touch with the agency. She stayed in touch. She was ordered to not violate civil or criminal law. She didn't do that. She took her parenting classes. And this is my other point that I make. They didn't put on a strong case that she didn't benefit for services. They didn't even call any of the service providers. And in fact, the judge went at serious great lengths to discredit the therapist's letter, who said that she was progressing. What was the basis for that? And it was almost like she was drawing on independent knowledges from other cases when she did it.
Counsel, it seems like the resolution of the domestic violence issues is a big issue.
Correct.
And and it seemed like, I guess, where is the clear reversible error in the court's assessment of sort of those issues persisting in a way that warranted termination?
Certainly. First, there's no new instances of domestic violence. She had removed herself from the situation. She was in a domestic violence shelter. She was getting individual counseling and group counseling, and her testimony on the stand was very good. So there's that. The second thing is I lost my train of thought. The second issue with the domestic violence is that she called the police. And
you participate in the individual therapy and domestic violence services that were referred to? It seems like the record indicates no.
there was a May to August where she said, I stopped going to counseling. She was honest about it, and the court credited her for being honest. But there was a 3-month period where she disengaged from counseling, 3 months. And she admitted to that. And she also admitted in the same silent line of testimony, I quoted that and put it right in my brief, where she said, are you ready to have the kids return home? And she said, well, right now I'm in a counseling. So I'm in a shelter, so it's not the best place. So she was very honest about her disengagement for a period from domestic violence and therapy. But then the therapist wrote a good letter. But here's my point. They really dinged her for this perceived interaction where the perpetrator calls up the shelter. And there's this give and take on whether she's supposed to answer the phone, not answer the phone, or just verify that he's calling. But that was their big complaint. That when she was at the shelter, if she called, they were going to ding him for a violation of PPO. That was their big complaint about her supposed contact with him. I mean, she had removed herself. She had called the police on him. She had gotten him arrested. She had gotten PPO. So that was all they had. I mean, if you my recollection of the record, that was their big complaint. I don't think that's that much. You know, if you're at the shelter and whether you want to get the guy in trouble for violating his no contact order, so you let them answer the phone. And they had some disagreement about it, right? Like she testified that the shelter told her she could do that. And then the caseworker took the stand and testified, no, the domestic shelter would never let you do that. But to me, I'm just thinking like, it's not a big issue to me. I mean, that's not, you know, whether someone decides to pick up the phone or whether someone doesn't decide to pick up the phone. If you're at the shelter and whether you want to get them in trouble or not get them in trouble, it's a non-issue for me. I mean, I don't think that is like proof that you didn't benefit from your domestic violence classes or training. I think they didn't have violations of no contact. So I don't see that barrier having. I mean, and don't forget, it's not that you have to show no reasonable likelihood that the barrier would be, rectified in a reasonable amount of time. So that's the standard. There's a perspective element to that standard as well. Yeah. So my notes on she obtained the PPO, she called the police, she separated from the father, acknowledged her role in the DV cycle, and demonstrated appropriate parenting in her parenting classes. Was in group counseling and individual counseling. That's what my notes reflect on that subject. I probably way over answered the question, but
that's okay. Thank you, counsel.
That's it. I think when you look at the timing that she was exported, both times her parenting time was suspended, it was because of unsubstantiated claims, right? Like the first time her autistic child is alleged to have been pinched, and she testified that the mom that she was in, because they when they went and interviewed the teachers at the school, they said this kid has a lot of physical behavior issues, etc. And the mom said that she had to bear hug, and that was a technique that she learned. And so, but they start services, and then right away in February they suspend it because of this pinching thing, and it turns out it was just the bear hug thing. And so and the one thing I'll say about this is you have foster care, right? Foster care, reunification, then you have these allegations, and a different investigator comes in. That's Child Protective Services, all under DHS. They come investigate it. Well, they suspend her. She doesn't have any parenting time during that whole period. She gets it back. That was in February. By May or by June, they suspended again because of another unsubstantiated claim. So of the 9 months, I always say, where's the carrot? Like if you're working hard and you're exiting this abusive relationship, the carrot is the time with your children, right? I mean, that puts it all front and center for you. And when you don't have that for more than half of the case because of unsubstantiated things, and you're only given 9 months, I think there's your clear error. And I'm here for any questions if you might have them.
Anything further? No.
We appreciate your time. Thank you.
Thank you as always.
Yeah, you know,
Very well
counsel-
presented.
Council, we really appreciate your ongoing continued efforts in this area, and we always appreciate seeing you as well.
Thank you.
Absolutely.
Thank you.
Okay, that case will be submitted. Item 23, case number 377427, Inree Cummins minor. Neither party is endorsed, so that matter will be submitted on the briefs. Item number 24, case number 378023, Inree Richards minor. No parties are endorsed. So that matter, I'm sorry, that matter also includes the case number 378576. In both of those matters, no parties are endorsed, and they will be submitted on the briefs. That concludes the call.